It's where we could work on that.
We're not on the record.
Oh, gee.
So sorry.
You gotta say your name.
Because I when I went out and got my dinner, I just wanted to see.
If you want to, otherwise we can just go over.
Just take it easy.
Sure, yeah, that's fine. The resolution and then the form document. Yeah. Thanks, Mercedes.
Maybe the so.
No, this is an auspicious. No.
That was exciting.
We did.
Does he ask
Oh.
for it, or does he just show up and throw you back in?
He did. She's like, you, now.
So you're still not online yet, right?
I don't think well.
It's
he's
filming
got it
because
running.
Pete's gonna be late, so he's got it running.
I'm so appreciative of all you do here. And your support and staff, it's exquisite. And you've almost got a harder job than I do.
Doubt that. Flattery will get you nowhere. We're already sworn in. So we do have a workshop portion of our meeting, which we will commence now until 7:30, at which point we'll start our regular agenda. And for our workshop, we thought it would be great to continue the tradition of review. Most of us should have these memorized by now, but some new members might benefit from review of our rules of procedure for public meetings. And this should take us the whole, depending on how much time we decide to spend on it. But if it doesn't, then we thought we would maybe spitball future workshop topics that we might be interested in hearing from our consultants on.
Yeah.
So with that, are you going to take us through the rules?
No,
Jennifer
I will, yeah.
The attorney.
So hopefully this won't take until 7:30, because I don't think anybody wants to listen about our rules of procedure for 25 minutes. But we will see. So yeah, every January, we review our rules of procedure. The planning board adopted its own rules of procedure several years ago. I think it was back in 2018. And we have a history of reviewing them every January to make sure everybody's aware of them and to see if there's any changes we want to make based on our experience from the last year. So everyone has a copy of them. There's also copies up on the podium if anybody in the audience wants to follow along. They are also located on the city website under the planning board page. So always accessible to the board members and members of the public. So I'll run through each of the rules. If you have any questions, just stop me and we'll try to get through this quickly. So number one, regular meetings. We have in our rules that we meet on the second Tuesday of every month at 7:30, preceded by a work session at 7 o'clock here in the courtroom, unless it's otherwise posted or noticed. Number two is a section on expectations for planning board members. And the expectations are that members are expected to attend all meetings of the planning board. If you are not able to attend, you're to notify the planning board secretary and the planning board chair as soon as you are aware of your expected absence. Members are to be familiar with all of the materials submitted to the board in connection with the pending applications. Members are required to complete training required by law. That's required by New York State General City Law and by the Beacon City Council to continue your service as a planning board member. Those requirements are for 4 hours per year. These training sessions, the work sessions that we have for this half hour before the start of our regular meeting each month, are intended to serve that requirement. If we fall short for whatever reason, or if you were not able to attend, there are lots of opportunities for other trainings through Dutchess County Bar Association, Dutchess County Planning Federation, New York Planning Federation, even Westchester Municipal Planning Federation. A lot of these organizations offer online programs as well as in-person programs. So if you are in a situation where you are attending a program outside of our training sessions that we have here at the planning board meetings, just let Mercedes know so she can, log that towards your 4 hours.
We typically don't have a problem through our workshops achieving those 4 hours for
We typically
the board
do
members.
not.
Yeah, that's good.
Yeah.
Just in case, curious, do professional CEUs count for the field of architecture? for example?
If it's related to really any topic related to your job as a planning board member. So if you're taking continuing education credits in your field in architecture, that's related to your job here on the board. So those would count.
Oh, great.
Yeah.
That's good to know.
Okay, so next, members are expected to be familiar with the provisions of the Beacon City Code that relate to your job as a planning board member, and the rules lay out each of those chapters that are relevant, as well as the content of the comprehensive plan and any other planning reports and studies necessary for you to discharge your duties. Section 3 deals with the chairperson. The executive officer of the planning board is the chair. The chair is designated by the mayor pursuant to the city code. And the chairperson has the responsibilities and authority specified in the Beacon Code and also in the General City Law of New York State. The chairperson is to preside at all meetings and hearings of the board, also authorized to sign all approved final subdivision plats, site plans, and any other permit approvals issued by the planning board. Another catch-all, sign all instruments made and approved by the planning board, perform any other duties as may from time to time be required, and call special meetings of the planning board. So special meetings are any meetings that the planning board holds that aren't on your regular meeting schedule, that second Tuesday of the month. One thing we may want to talk about that came to mind as I was reviewing these rules related to this section is the provision that says that the chairperson is authorized to sign all approved plats and site plans. In the event the chairperson is not available, we should have a designee assigned. For example, if there's a time crunch for an applicant and we need to get the final plat signed and filed in the county clerk's office, and you happen to be on vacation,
Yeah.
otherwise unavailable,
Well,
we
historically,
should,
it's been Randall, right? Yeah.
Yeah.
As our designate, and stand-in should,
yeah.
yeah.
So if that, yeah, so we should,
wanna
we should
memorialize
probably
that.
memorialize that, that the chair can designate a designee
Within the rules.
within the rules,
Yeah,
yeah.
okay.
Yeah, I mean, we don't have to name Randall specifically, but just have that authority for the chair to be able to designate somebody else.
Great.
Okay, number 4, guidelines for planning board members. Planning board member has to be recognized by the presiding officer, i.e. the chair or acting chair, before speaking and/or making a motion. A member shall address the chair and shall wait to be recognized.
That's for you, Jim.
And others.
Call you a certain Mr.
Your Honor.
Your Excellency.
Your Excellency.
Excellency, Mr. President.
Secondly, conflicts of interest. So this comes up from time to time. You cannot participate in a matter if you have a conflict of interest. And if you do suspect you have a conflict of interest, you should inform the chair, the planning board secretary, and the planning board attorney. If you do have a conflict of interest, you would recuse yourself from considering that particular matter. You should not receive any of the materials related to that matter. If you do receive them by accident, notify the person that sent them to you and disregard them, delete them from your inbox. You should also...
There have been some instances where there's, the possibility of conflict of interest, and, always if there's even just a hint, maybe, ask Jennifer, because Jen, you're usually really great about, letting us know whether in fact, because there's times when I've thought maybe this is, and it hasn't been. And then vice versa, even if you're not sure, just reach out.
And you can still
Absolutely.
disclose that on the record so that it's kind of stated, but then
Right.
not a conflict not identified.
Yes, yeah, so in advance of a meeting or even during the meeting, if you think you may have a conflict, absolutely reach out to me. I can help, analyze that issue. If there's still a question, you always have the opportunity to pose the question to the city ethics board. We do have an ethics board. And
We
they
had
would,
one.
yeah, and they would resolve that question as well.
Jen, can you give some examples of of what would be a conflict of interest?
I mean, the most obvious one involves like financial interest, like if you own the property that is the subject matter of the application, or if you serve as like the real estate broker for the property in question, and if the application is approved, therefore, and goes to sale, the sale is consummated as a result of that approval, and you would get a fee because of that. Obviously, you have a financial interest in the application, and in those instances, it's very clear that you should be recusing yourself. Simply like knowing the applicant in a familiar, you're friends with them, you went to school with them, you know them professionally, that's not a conflict of interest per se. If, because of the nature of that relationship, you feel like you can't be impartial and you can't like look beyond that relationship, and you feel that you would be biased, then you should recuse yourself. And that's sort of the, even when there's not a conflict per se, we still need to look at whether there's an appearance of impropriety. So that's why each of these situations can be unique and really fact-based, so that's why it's important. If you feel like you have a conflict, you have a question about it, reach out to me, and I'm happy to help walk you through that analysis.
Jennifer, John, I'm going to pick on you, sorry. So as an architect, if he was working for somebody that then came before this board, but yet he's working for them on another project, that could be perceived as...
It's possible, yeah. Again, they're all very fact-specific. So we'd have to look at it in the context of, the facts as they're presented,
Yeah.
but it's possible.
Yeah, I mean, the way I look at that is if any one of our firms came before us, we would need to recuse,
Yeah,
right, regardless of whether we're actually working on that project or not.
Right, I'm just saying,
Yeah.
I've dealt with it in different municipalities where I've worked for a client and they've appeared where I've kind of had to recuse myself.
Sure.
Because
Yeah.
I had a project with another consultant, but because I'm working for them at the time,
Right.
there was that perception.
yeah.
I think also just throwing it out there, I think it's only, at least at this point in time, pertinent to you and I, but in certain situations, you could have that standard come up at a little bit lower of a level, in particular, like as attorneys. If you've got an active attorney-client relationship with a party, regardless of the lack of a financial interest, because you literally got an obligation of loyalty to your client under the rules of conduct, you're also necessarily going to have a conflict of interest.
Yeah, absolutely.
Good to know.
Yeah, I gave the financial example as like a very clear cut, but you're right, there are lots of other circumstances, especially as attorneys, where that could come up. And Chapter 29 of the Beacon City Code is the ethics code. So if you're not familiar with that, take a look, read through it, especially if you're trying to go to sleep at night and can't, that might help. All right, so moving on, the next section is non-disclosure of confidential information. As a planning board member, you are not to disclose any confidential information that you receive by reason of you being a planning board member. And this can come up in a number of different ways. This could come up if you receive, confidential information through application materials that are submitted that are marked confidential. This comes up very rarely, but because almost everything that's submitted to you is accessible to the public. But another example would be, for example, when we have closed sessions for advice of counsel, that is an attorney-client communication that is privileged, and that's confidential information that you're receiving based on you being a planning board member. So that's information that should not be disclosed outside of the planning board. Moving on to the next section, meetings. So our meetings are subject to the open meetings law, which means that they have to be properly noticed in accordance with state law. That is except for meetings with your attorney for the purpose of attorney-client communications. Those meetings are outside of the scope of the open meetings law, which means we could have, for example, a conference call or a Zoom meeting that's attended by a quorum of the board where we're discussing planning board business. Normally that would have to be noticed to the public, but if it's an attorney-client session and you're getting advice from counsel, we do not have to notice that as a public meeting. We could have that as a conference call, a Zoom call in Randall's living room, whatever the case may be. Otherwise, we are subject to the open meetings law. As I mentioned, so a quorum of the board constitutes a meeting when you are discussing business. So if 4 of you happen to meet in the supermarket and you're talking about your weekend plans, or that just because you have 4 members of the planning board together, that doesn't necessarily mean that you're having a meeting in violation of the open meetings law. If you all of a sudden started to talk about next month's agenda and the pending applications, that would be a problem. That would be a violation of the open meetings law. Same thing with email and text messages. There shouldn't be any, substantive email discussions or text messages about planning board business. Public hearings, the planning board is authorized to hold public hearings in addition to those required by law. So if there's a matter that doesn't necessarily require a public hearing by law and you think there should be one held on that particular application, you're authorized to call one. And that would have to be placed on the agenda. Site visits, you may conduct site visits either as a group or separately as individual members. The determination of whether a group site visit is going to be performed has to be made at a regularly scheduled meeting. Those visits are, whether they're individual or by group, are limited to touring a site and getting factual information pertaining to the site, but are not for the purpose of having substantive discussion about the site or the application. That has to happen here at a publicly noticed meeting. The concern about having the substantive discussion is then all of a sudden that turns into a meeting that needs to be noticed pursuant to the open meetings law. Also, members of the public are usually not allowed to participate in site visits unless the property owner allows them to come onto the site and invites them to attend. Number 7, proceedings. The chair is to preside at all meetings of the planning board. In the chair's absence, the chair will designate an acting chair. Under New York State law, renoticing a public hearing is not required after the initial public hearing is held and continued to a specific date. So we have that all the time, right? We open a public hearing, it gets continued to the next meeting. We don't have to renotice that through publication in the newspaper and mailings to the neighbors. If we were not to specify that adjourned date, and we just said it's adjourned indefinitely and we don't know when the applicant's coming back, then it would have to be renoticed when they do come back. Let's see. So the next section just kind of lays out the format of the meetings. We have a formal presentation by the applicant describing the application. The chair identifies any correspondence that the board received from members of the public or otherwise. And then so it can be opened up for public comment for a public hearing. Let's see, written materials submitted by the public have to be given to the chair and entered into the record. No action can be taken until we have the public hearing, and that public hearing is closed. Motions, when a motion is made and seconded and under debate or discussion, no motion shall be received except to amend the motion, put the motion to a vote, adjourn or table it, adjourn the meeting, or withdraw the motion.
What does that mean, no motion shall be received?
No, like, additional motion. So if you have an active
Oh,
motion
so
on
you
the
can have
table.
multiple motions happening at once. Okay.
Exactly. In terms of voting, we need a majority of the whole membership of the planning board. We have a seven-member board, so we need at least 4 members for a quorum and to conduct a vote to pass. And that counts even if we have a vacancy. So it's always judged by the 7-member board, even if there are vacancies. The chair has the same right to act on matters before the board as all the other members, including the right to make and second motions. And the vote on the motion has to be recorded in the minutes. Each member of the planning board is expected to vote on all questions before the board, unless you're required to abstain or you're recused. And if you're abstaining, you need to cite your reason for abstaining. The second part of this section talks about what we've already discussed with conflicts of interest, disqualification based on a business or financial interests. It refers you to the Code of Ethics. This next section is important. It's guidelines for comment at a public hearing, and this is the expected conduct for all people who are speaking at the podium and speaking to the planning board. And these are the standards of conduct. 1, speakers have to step to the podium to address the planning board, so we can't have members of the public speaking from their seats. Before addressing the planning board, the speaker has to give their name and their address and any organization that they're speaking on behalf of. Speakers must address the members of the planning board and need to avoid speaking to any one planning board member in particular, or to the applicant directly, or to the general public. The point of public comment is for commenters to give comments to the board, not to the applicant directly, or not to the other members of the public. We limit public comment to 5 minutes, but the chair can reduce that to 3 if the chair deems that appropriate. Speakers shall generally observe commonly accepted rules of courtesy, decorum, dignity, good taste. We're just trying to make sure that everyone respects everybody else here, which I think everyone usually does a very good job of. Any statements, comments, or remarks made by a speaker cannot concern the motives of a planning board member or constitute a personal or political attack or criticism of any member of the planning board or officer of the city, consultant, employee, or the public. The audience shall be respectful of all speakers and refrain from comments and gestures, private discussions, cell phone use, and otherwise interfering. So this comes up, sometimes we have situations where a member of the public gives a comment. Many of the members in the audience may agree with that comment and clap. That is not necessarily appropriate to clap or cheer or boo. it tends to be disruptive to the proceedings. Any speaker who fails to conform, the chair can direct that person to cease speaking and yield the floor. This is also important. The applicant and the applicant's representatives are not bound by the time limits. So the applicant is not bound by that 5-minute limit. That would be impractical. But they're allowed to speak for such time as permitted or allowed by the chair. Surprisingly, we're running out of time. This is taking a lot longer than I thought, so I'm going to skip through, let's see. The planning board has the authority to make recommendations to the city council related to any matter that's within your subject matter jurisdiction, including proposed legislation. It doesn't necessarily just have to be in response to a referral from the city council, but you can proactively make recommendations to the city council. I think that's important to know. Also, planning board members, regarding communications, refrain from engaging in what we call ex parte communication concerning an application. So there should not be discussions amongst yourselves or with applicants or their representatives or even potential applicants or members of the public about pending applications outside of a meeting. So don't talk about planning board business outside of a meeting, basically. If you do, if that does occur, shouldn't occur, but if it does, at the next meeting, you need to disclose that discussion for the record during the meeting and relay the contents of it so it is in the record. In order to avoid the appearance of impropriety, applicants are not to communicate directly with planning board members. Applicants communicate through Mercedes, through the planning board secretary, and through the board's consultants, your planner, your engineer, and myself, as well as the building inspector. And then minutes of the meeting. Minutes are kept of all the planning board meetings in accordance with state law. Mercedes does an excellent job.
Indeed.
Of taking those records, and we appreciate that. And these rules of procedure can be amended from time to time as you need to by a majority vote.
Thank you.
That is it.
Do we need to vote for the alternate to be put into this?
Yeah, so we should, so in section 3B,
I thought the alternate was appointed.
But to amend these,
For the signature.
so the acting chair is different than, we're talking about the designee for signing plans
designee
in
for
your
signing.
absence.
Okay. Isn't that the same, the acting chair? No. Different.
We can say in here, well, because the acting chair could be different.
Yeah, it could
If you're
be.
going to be
All right.
absent.
Makes sense.
And you designate, say you designate Randall, but Randall's also not going
Right.
to be here.
Can the designee be a city employee, or does it have to be a member of the planning? Because if we're trying to get around, say John's not around and a plan needs to be signed immediately,
Yep,
can it be city staff?
it can. So it could be,
Okay.
many
Building
times
inspector.
it's the planning board secretary is the designee. So if
Oh,
you'd
okay.
rather
That may make things a
designate
little
the
easier.
planning board
Yeah.
secretary, that would be fine too.
So, we're not in actual session though, so we can't actually act, but we could once we open the meeting.
Yeah.
Yeah, okay. So we'll put that on the agenda, but before we open the meeting, and thank you, Jen. If there, I don't know if there's any quick questions of Jen on the rules of procedure. I know we've been through these a number of times. Most of us here are pretty familiar with them. Otherwise, the other thing we wanted to discuss, but we'll hold over till next meeting, is, any ideas you have for future workshops. I think, David, you mentioned one of our meetings, an idea you had on something legal law related.
Yeah.
So if you have thoughts and ideas on, we'd like to try to fill out the calendar for the year, just shoot an email over to Natalie.
Okay.
Yeah.
We'll work to do just that. And then before we open the meeting, we just have a little bit of business. Our esteemed mayor is with us tonight, has already sworn myself and Mr. Vermeulen in to our terms, and so needs to also swear in David and Kevin. So we want to take care of that, and then we'll open the meeting.
In seriousness, that's all I'm here for. But in jest, you're now a majority, was sworn in 5. You guys want the other 2?
Oh, wait, I didn't know we had a choice. I thought this was by fiat.
So I'll just take a minute. We'll do it right here. So I'm the officer that's authorized to be sworn in. All right. Who are you? Oh, yeah, okay.
She mentioned beneficial.
And then I will say the
So it's definitely.
We can make that. Okay. Yeah.
Kevin, you have to sign. I have to sign? Yeah, my goodness. That is super official. I forget all that stuff.
John, first things we should sign, maybe the building inspector is the designated.
Oh, okay.
If you're okay with that.
Is he okay with that? You want to be there? Sign.
You giving me blank checks to sign?
Sign.
Sign anything you want. I can practice your signature, sure.
Yeah.
Yeah, I mean, so typically it's kind of like by committee that we double check and make sure all the conditions have been satisfied. We have like Natalie sign off and John sign off. Yeah, it's kind of a team effort. Yeah.
Okay. Congrats, guys. Welcome back.
Thank you.
Thank you, Mayor.
All right.
Great to see you.
Have a good evening. I was just up at Albany at the State of the State.
Wow.
So,
It's
yeah,
exciting.
it's kind of good to watch kind of government starting up every year.
Yeah.
And again, I'm always appreciative of the appointees and of their support staff, so thank you.
Thank you.
Thank you.
Good night, Mayor.
Okay, so we will formally open the meeting. Welcome, everybody, to the first meeting of 2026, the January meeting of the City of Beacon Planning Board. First thing we'll do is, if there's no further discussion, designate Brian as our alternate signatory. Is that what we're calling it?
Yeah, so under your rules of procedure, under 3B, one of the chairperson's responsibilities is to sign all final plans, essentially, once all the conditions have been met. In your absence, we should have someone designated. So the amendment to the rules would be that in the chair's absence, the building inspector is authorized to sign those final plans.
Okay, great. And you're comfortable with that? I am. Excellent, good. So then I will accept a motion by the board to do just that, to amend our rules to designate our inspector? Building inspector? Where are you? As designated signatory in my absence.
Motion.
Motion by Randall,
Second.
second by David. All in favor?
Aye.
Aye. Great, that sounds unanimous to me. Good, and then second order of business before we go into regular agenda will be to adopt last month's meeting notes into the record by formal vote. Before we do that, any discussion around amendments or other changes to the notes? If not, then I will accept a motion to adopt last month's meeting notes into the record.
Motion.
Motion by Karen.
Second.
Second by James. All in favor? Aye. Aye. Great. So we'll move to our first agenda item, which is to continue our public hearing and continue our review of applications of site plan approval and special use permit Hotel and Restaurant, 1064 Walcott Avenue. Good evening.
Good evening, Mr. Chairman. Happy New Year, although
And
I
you.
think,
Thank
according to Curb Your Enthusiasm, that's long since past the statute of limitations. For the record, Taylor Palmer with the law firm of Cuddy and Fader. Tonight, I'm joined by the project architect, R.A. Siegel, as well as Mike Bodendorf of Hudson Land Design, and our traffic consultant, Rich DeAndrea from Colliers. As you mentioned, Mr. Chairman, we are before you for our continued public hearing for applications for site plan and special use permits proposing to adaptively reuse the 2 existing buildings on the property and install an addition connecting the existing southern building for the purposes of a hotel with 48 rooms and the accessory restaurant. The public hearing was opened back in December, at which time we provided a detailed project background. So to briefly summarize for anyone here in the public this evening, we are proposing to redevelop the property for the proposed hotel to be known as the Inn at Spy Hill. Will include 48 guest rooms, associated guest amenities, as well as a lobby, reception, gym, and use for the hotel guests specifically. The project will also include an accessory restaurant, which is proposed to be open to the public. We do have a lot of ornamental and functioning landscaping that is proposed as part of this site plan, and parking will be provided for hotel guests and restaurant users for a combination of on-site and off-site spaces utilizing a valet, which I'll get into in just a moment. Before I do turn it over to R.A., Mike, and Rich, I do want to provide a brief summary of some of the updates from our December 30th submission to you all. So following our discussions last month, we were able to put in, continue to develop our engineering, traffic, and parking, as well as our landscaping. We did submit our lighting details. I know that was a request at the last meeting to do the programmatic elements of the project and to enrich the overall project design. The landscaping plan was developed by Deborah Adamsons of Landscape Restoration, and it's been supplemented to include additional trees and shrubs at different heights to provide screening for adjacent properties. In addition, the proposed plantings along the south side of the driveway were modified so they don't interfere with vehicle sight lines. The location of the proposed mechanical equipment was identified with landscaping areas for the proposed addition, so that's also going to be shielded by proposed vegetation. Formal lighting plan was included with the luminaire schedule. As part of our secret review, we also retained Beth Seelig of Hudson Cultural Services, who submitted the project materials to the SHPO on January 9th. So while we hope to have their response to you this evening, we're still waiting for that, but it is now accepted, and Chris has the token, so that secret component is in the works. So with that, as requested by the board and its consultants, we also updated our stormwater management, engineering, and construction details have also been added to our plans. We'd also like to update just a few other things with respect to the parking. As a reminder, the applicant is proposing 39 spaces on the property, and then the number of spaces is compliant with the code, which requires 27 minimum and 77 maximum for the site. And Rich will touch on that just a bit more in a minute. But we do anticipate additional parking spaces that were needed. So to accommodate that, we did propose valet parking to bring that number up to 49 vehicles for on the site. We've also reached an agreement in principle with the owner of the Riverview Funeral Home located at 2 Beekman Street to allow up to 14 additional cars to be valet parked at that property as needed. So that'll be a permanent license agreement that's been drafted and finalized, but we still have to have the autographs on that one. So we'll submit that in a future submission, but that will be for 14 total spaces. So we'll be able to exceed the peak parking demand with the additional off-site parking. Additionally, the applicant will be seeking an area variance for the rear yard setback. That was a request, and the board wanted to clarify where we were going there. So as part of tonight's review, we will ask the board to consider positive referral to the zoning board, which we then submit and come back to you all. So with that, I'll turn it over to RA just to kind of walk through these project changes, and then turn to Mike and Rich to the extent you guys have questions on those aspects. Thank you.
Good evening. Yeah, so we submitted revised drawings based on the comments that we received at the last meeting. There are a few things that we try to finalize now, the location of the mechanical equipment and the screening. That's sort of under that retaining wall, so it'll be totally blocked from.
Can you highlight that in a little bit more detail for us?
Let me see if I can blow that up a little bit. Yes, it's this area in the corner of the retaining wall behind the addition.
just describe the approach, just from,
Oh, okay.
Point
So,
zero.
so the retaining wall is, I think, close to 6 feet high, so it's going to be, screened from the, that rear property line, so that the neighbors wouldn't see it. And then it's also has a fence around it and landscaping in front of that, so it's pretty well screened in that corner.
and so what are these? These are condenser units?
Yeah.
How many are there?
Hasn't been engineered yet, but we kind of oversized it to allow for several. And they can be stacked, so I'm confident that we can fit them all in there.
So when you stack them, they're not, you're confident that they're not going to, I'd almost like to see a section with the actual units, they're not going to appear above the 6-foot retaining wall?
Right. If we need to stack them, but I'm not even sure we would need that yet.
So these are they're going to be mounted on what, pad on the ground?
Yeah.
Yeah, it's hard. So that area you're pointing out, it just looks like a bunch of, so it's, I see, it's, what you're drawing is a trellis. You're not actually showing the units themselves. Right? So it's just an area designated.
Right.
So, and that trellis is visual screening from any view that might be achieved from above?
Yeah. Just to sort of enclose it from that angle as well.
And so you're intending then to grow something across that trellis to further obscure?
Mm-hmm.
That's in, what is that, Vine TPD? Right?
Yeah.
So you're going to obviously determine some species at some point, right?
Mm-hmm.
Okay.
And if for some reason, if it did need to grow a little bit, the same theory would apply, and the same level of screening would occur.
Sorry, what is that?
If for some reason, if we needed more condenser units in there, we could slide over to the left a little bit and increase the size of that enclosure and screening. It would still work if it had to be increased for some reason.
I see. Yeah, I mean, I'd be curious for the number of rooms that you need for the square footage. I mean, this is big. I'm no engineer, but I almost feel like you're going to need a lot more room and a lot more units than that. But I'm not an engineer. So, okay, well, so we'll look forward to see more development on that.
Mm-hmm. But you want to see the vine exactly and the section through there?
Yeah, I think we've had so much challenge with these units on past applications and screening being described in a planning board meeting and then the real thing coming out and not looking anything like we imagined. So I'd rather get tight with what this is actually going to be.
Okay.
And what you're actually going to build.
Yeah.
And really specific.
Okay. Yeah, I mean, fortunately, this is kind of set up to screen it pretty easily. So, but we'll give you the detail on that.
Okay.
So we also got the photometric plan from the lighting designer, and I don't know if you had a chance to review that in detail. But
who's the lighting designer?
I don't have his name here. He's a rep for.
He's a rep. He's
yeah.
not a lighting designer. Yeah.
Yeah.
It's okay. We could talk more. I don't want to hold this up now, but it's bare minimum done by your rep, not with a lighting designer eye. You have conglomerate-based architectural fixtures here that are just meant for, prisons and parking lots, right? There's no subtlety or deep understanding of what this should look like, and there's certainly not being presented to us in a way that we can see what the intent is. I guess one of the things I would ask is, what's your overall lighting concept for the project?
Right. Well, I mean,
and it can't be determined in a single flat, 0.1, 0.2
right.
Photometric data sheet.
Right. I mean, we are going to, you know, I wanted to get some, you know, initial feedback like that and then incorporate the lighting and the fixtures into the next round of rendering. So, you know, we would
Great.
see how it's reflected. But the idea was, you know, building up layers, and that's, you know, what we sort of asked them to do. And,
Great.
but, yeah.
Haven't been a rep, haven't been a lighting designer, haven't been all aspects of lighting business.
Yeah.
Do not go to your rep to do lighting design for the city, right? They're just incapable, right? They're not lighting designers, right? It's like asking someone from the Home Depot to help you build your house, right? It doesn't work.
Okay.
Okay, so my suggestion is please hire a lighting designer. This is a big project. You got such beautiful details here, especially in the landscaping. And if you hire a lighting design firm to do this, you'll get everything that you need from it. And they'll go at it, you know, by bare minimum should be following the IS guidelines. But we want to beat them, right? And if you follow the IS guidelines, you'll at least get to something that looks okay. But until you engage a lighting designer who's going to create a design concept, you're never going to get past an engineering photometric data page. Okay? And I'd love for them to show up and talk to us about it. It would be amazing.
Yeah. Okay. So another thing that we talked about last month was kind of beefing up the landscape design. So you know, we submitted additional material there and showed some additional screening for the neighbors. I'm also going to work with Deborah to get that information on the site section so you can sort of see it in action. And she's also working on the survey of the existing trees. So we'll have those located on the plan, showing what, you know, what's going to stay, what's going to go. And I believe we should have that by the next submission.
Sorry, did I hear you say that working with Deborah, you're going to establish your approach? And again, it looks like the plans are starting to fill an approach out. And then update your renderings to reflect that approach as far as the landscaping?
Yeah.
Okay.
We're going to keep, you know, updating those and getting it, mainly for the landscape and lighting changes. So.
Thank you.
Yeah. So the other thing we're doing, we're putting together some more information on the historic North Building, so we can, you know, give you that more detailed description of what's changing, and also, and again, this will be reflected in the renderings, is how we're going to differentiate that from the you know, the new project.
Okay.
And yeah, I think that's the basic update.
Great. Thanks.
Thanks.
Thanks, Harry.
Thank you.
I don't have a whole lot to add tonight because Taylor pretty much gave you the entire update. But essentially, last time we were here, we reviewed the valet parking plan that showed 49 spaces on the site with valet. Our analysis had showed a need for 62 parking spaces. So we did go out and identify a location at the Riverview Funeral Home for an additional 14 off-site spaces that would be utilized via valet as well.
I'm just curious, what mechanism in terms of an agreement with the funeral home are you thinking of entering into? That guy.
Permanent license agreement.
Permanent? So
With
kind
P.
of an easement?
It's a license agreement.
So would it carry with ownership?
It would carry with ownership, and it would be revocable only by the applicant.
Okay.
Yeah, so that, Mr. Palmer and I had a discussion after you and I spoke earlier today. My understanding was that it was a license agreement, which it is. My concern was that it would be revocable by either party, including the property owner in which they're parking the cars. And if that's revocable at will at any time, and we're left with no area for the overflow parking, that's a problem. It still remains an issue because if the owner of 1064 Walcott elects to terminate for whatever reason, we're still left, right, without an overflow parking area. So I think we do need to still keep that in mind and talk about some triggering mechanism, for example.
Should have been
something-
terminated, they need to get back here.
Correct.
Exactly, come back for amended site plan review in the event that that is no longer available.
I have a question. I think that it would be advisable because if the use ever changes on the funeral home
Yeah.
in the
Yeah.
future,
Right.
and there's, it blows up that agreement or it becomes an issue, we wouldn't want to see them in trouble behind that. We want a mechanism to fix it.
Yeah, we'd accept,
Exactly.
it makes perfect sense to include a condition to that effect.
Yes.
It seems like the
Karen.
most direct solution would just be to have an easement. I mean,
The enforcement mechanism, it's the same power.
Yeah.
It runs with the land, they can't, the regulations or how it will be applied, it'll be the same. It's just revocable by our property owner to the extent the same way that I think Mr. Williams just mentioned, that if there were a change of use or other things, they could come back and say, this is no longer a hotel, it's no longer a restaurant, we don't need it. So they'd have a revocability for the property owner to say, we don't need this anymore. But the point is, Ms. Gray mentioned, is that you'd include a condition that if those changes happened, we'd be back before you to ensure that it satisfies your traffic consultant and meets those, or parking consultant.
Right,
meets those criteria.
that's the ultimate intent. Sorry, Karen had something.
But it's a permanent license agreement. Sorry, Karen, go ahead.
Yeah, I'm just curious on how you address the times in which the funeral home needs all of the spaces that they have, and they don't have the 14 spaces to share.
Yeah, I mean, I think that's something that needs to be worked out between the two, between this owner and that owner, as far as times of use. But the intention is that they're going to be available, when we need them, which is going to be in the Friday, Saturday evening at night, when our peak time is. Our peak time is 10 o'clock at night, really, 9 o'clock at night, when, based on our analysis, so.
And the major need is based on the restaurant, not necessarily the hotel rooms.
Yeah, I mean, it's assuming that the hotel is full and that your restaurant is at peak use,
Okay,
basically.
so it's a combo.
Yeah, right.
Okay. Randall, did you have something?
It's just kind of, it works for both, I'm sorry, it works for both the restaurant as well as the funeral home, because the funeral home ever changes its use, the same issue could happen. Also, I was going to say, and I don't recall the requirement for parking at the funeral home if there was an excess of parking. So it would be interesting.
I can tell you from my experience driving by Beekman from the station that when there's a service there's cars.
Last service, it was overflow onto Beekman.
It was on to Beekman. There was it was actually quite a dangerous situation.
Right, and what time was that at?
They don't have enough parking for their needs right now.
Roughly 7 p.m.
7 p.m. on a Friday or Saturday?
A weekday.
Any day.
Yeah, I think we understand there's also an application.
They're not planned events.
Right, and Dia is seeking additional, no, of course, well said, but there is no, stole my line. But Dia is also seeking additional parking, like there are other opportunities that are being pursued throughout this area of the city, so there are potential other optionality that could exist, but right now we've done what is typically asked of us as an applicant, which is to seek a permanent license agreement or easement to provide for those parking spaces, which we have. There is always the opportunity that there could be a conflict, but the rarity of that is, to the extent that these conflicts do exist, I call it the Black Friday sale. There's that one day of the year where it's I think somebody just said it, a real mess, and there's only so much you can really do in that context, but would it rise to a significant potential adverse environmental impact when the applicant really isn't? These are peak demands that are being met and have those opportunities for shared parking.
I will say this, it recently, the situation with the funeral home on its own has risen to the level of a real mess already, right? We're not just talking about overflow, we're talking about people parking on Beekman and obstructing flow of traffic up from the train station in a significant way. So, we don't want to, I understand what you're saying, but we don't want to take it lightly. Right?
Understood, yeah, we can.
Any variable that potentially impacts the volume and the need there is going to make situations like that worse. It's as simple as that. I don't want to candy coat it.
So, not part of this application, but the last application on the agenda tonight, Dia is building a new 49-space parking lot. They do have an agreement that they're working out with the funeral home, so there may be some leeway there. Just wanted.
Do you saw an opportunity? Put up a parking lot.
Still parents.
Build it,
Anyways,
they
I'll
will
let
come.
Rich continue.
Yeah, I just want to make sure there's a mechanism to fix it
Yeah.
at the time when it needs to be addressed. That's the most important thing.
Also, is there a need to assess what the actual parking agreement was for the funeral home and whether there is actual,
It's worth looking at. Yeah. So we trust that you'll be digging into all of those
These,
aspects.
the property owner that's before you and the property owner that owns the funeral home have had a working relationship for a long time. This is not like this won't be a new operation between the two of them.
Right, but it's not about, how well they get along. It's what's the existing use and requirement of the parking for the funeral home in and of itself, and whether there are any extra spots for them to rent out.
Okay.
The only other thing I wanted to add was, we talked about site distance last time at the driveway, and that there were some trees to the south of the driveway that were blocking the site distance. Those have been corrected. I think there's some things that need to be cleaned up on coordination things between plans and
Yeah.
views and stuff, but that'll get done.
Yeah, that's why I mentioned the renderings.
Yep. The only other thing that we did recommend as part of our most recent submission was the installation of a intersection ahead sign with a driveway plaque below it, about 200 feet before the driveway, south of the
South,
driveway.
yeah.
Just to alert drivers of the approaching that driveway, because the site distance is still a little challenged by the slope on that area.
Yeah, I mean, I've driven it a few times. Sometimes I take that left coming home from work. And, yeah, I mean, I see what our city engineer was mentioning. There certainly is enough distance to perceive a car coming out, so that as you approach, you have time to respond.
Right.
But I think any obstruction, so it's good that you're removing some of that potential visual obstruction through plantings. And signage is, to the extent that it's not clutter and it's actually helpful.
Yeah.
I think it could be.
I think it's just, we're just looking for that extra level, extra level of safety with that addition on that sign. So.
Yeah, okay. Good CYA to have a sign there.
Rich, the only thing is we didn't receive the updated plan. In your correspondence, you referred to an updated plan, SD-01, which was submitted the last time with the report.
Oh, it wasn't attached? Okay. We'll make sure that it gets included.
Okay.
Thanks. Okay. Since you jumped in, you want to cover any highlights on your review notes at this point, John?
Sure. So I had some comments on the lighting plan, but I think Jim's covered that quite well. With regards to the stormwater, the applicant has shifted the stormwater proposed on the site to the rear of the site where it originally originated. We do have a number of comments with regards to that, specifically with regards to the proximity in the retaining wall. DEC's code now requires 25-foot separation. I have had a conversation with their engineer. They may be discussing this further with DEC, trying to seek a waiver to see if they can reduce that down. Otherwise, they may have to modify their design. We're still looking for the soil testing to be done sooner than later.
Sorry, your earlier comment, does that mean we're looking for an updated SWIP still?
We're looking for updated SWIP, yeah. So where they're proposing their stormwater now is where it originally was when the project started. Last time they were before you, it was actually in the front of the site. Now we're to the back.
Yeah, I'm just asking relative to where we're at with SEQA on this. Okay.
So we have a number of comments. Now, the rest of it is cleanup work and some modifications.
Natalie, anything you want to highlight?
Ari covered it slightly, that I think what we're looking for, there is a section within the HCLO, the historic overlay, about restoration of the building. So I think the board has worked a lot in the past few meetings of the addition and how that's in conversation with the existing historic structure and the existing structure to the south. So there's just some comments there about it's within the code to kind of, for this board to verify the changes that are occurring on that historic north building, and making sure that the historic integrity of the structure is being maintained. And then also, I guess my one comment, and that we talked about this briefly last time, is within the Department of Interior standards that the state uses, as well as the local, there is a guidance to kind of have some differentiation between you can have conversation between the buildings, but have some differentiation to kind of highlight the historic building itself and make it stand out a little bit. So I think REA said that they're going to be working on that. So I just kind of reiterated that in my letter so we don't lose that. I think I'm still trying to understand with the landscaping plan. I love this is a very detailed landscaping plan. I think there's a lot of variation in terms of the plantings throughout. I think one of the things that can never be undervalued is retention of trees where it's possible, though. So I think I've been asking for tree removal, just so we understand what existing, like, grown trees will be removed. That way we can better understand how this new landscaping is going to be kind of layered.
Yeah, Deborah has it, we just didn't have time to get it for the submission deadline.
Because I think that will help with the screening, because if you have a grown tree that's being retained, that does a lot more screening than something that's going to maybe take a few years to grow in. So just trying to understand the play between that. And then I was just trying to see I guess to John's earlier comment about the mechanical equipment, is it intended to be the same detail as the trash enclosure, or is there a detail for the mechanical equipment enclosure? And if not, maybe that can just be added to the additional detail.
Yeah, it's going to be the same privacy fence, so
it'll look the same as that trash enclosure detail.
Right.
Okay.
Because we wanted to make it solid and the same 6-foot height.
Okay, but then with something over it, I guess.
Right.
Okay. I think that was it for my comments.
Okay, great, thanks.
Yeah.
Board, any other, before we still have open public comments, so before we go back to the public, any notes or other questions for the applicant or our consultants?
I have a couple of comments on the planting plan. There's just some cleanup on the tags, the labeling of the planting plan. And if you could provide existing pictures of existing conditions, both from the street for the existing pine tree row and from the back, just so we can assess what screening needs to happen for the existing additions.
Cool, thanks. Anything else, board? Nothing. Okay, we'll go to the public. Anyone here who would like to share their thoughts on this application during this part of the public comment section? Just hang out for 30 seconds in case somebody decides they want to say something. Yeah, or somebody comes in.
Could like play the Jeopardy.
Yeah. Okay, so, yeah, just as far as keeping public hearing open,
Close it. What? Sorry.
I'm sorry?
Go ahead.
We could think about closing at this point. What are your thoughts? It looks like you have some thoughts.
There hasn't been much public comment on this application,
Yeah.
and clearly nobody tonight. But there is some information that the applicant
Still stuff we need to look at,
is,
yeah, so fair enough.
we've discussed it, and we sort of know what's coming, but it hasn't really been vetted
Yeah.
in the public yet. So.
Plus, you still have.
So if I may, we do have to go to the, so we have.
You still
part
have
of
a journey
the request,
to the
we have to go to
zoning board,
we have a
yeah.
public hearing that we'll have with the zoning board. And I think to the extent that, so the changes that you're seeking from us, whether it's the stormwater or some of the landscape components, they're not full new plans or full of reinventing the wheel from a seeker issue more so than a public hearing issue. We're addressing those considerations, and I think for purposes of a public hearing, if there are substantive or meaningful changes that even came out of the zoning board, the applicant would commit to re-noticing or reopening a public hearing as needed, so to the extent.
There's also renderings of the back that we asked for.
Yeah, the screening and lighting issues are.
I'd
things
feel
that
better
pretty
if we just
significant
stayed
for the
open.
public.
Yeah. So, again,
If I may, they're not here, right? They haven't commented regarding the application. So new information is based on the board's request. So the intent of the public hearing is to provide new information that's not been.
Let's look at it this way.
Sure.
We've made this request. We assume you'll come back next month with responses to those requests.
We will.
If the public hearing is still open, the public still has then the ability to respond to those new components. So for that reason, I think we're all making the argument that we rather, and I don't think it's much skin off your teeth because you still have your zoning board journey. So
Part of it
we
is
could-
just going to be procedural, so the next request, as you may expect, is just potentially
Your
drafting.
recommendation.
Secret determination, because
Oh.
we'll be at the zoning board a week after we meet with you all, and the zoning board won't be able to act until.
So, fair.
Yeah,
I think we
secret's
can talk about draft secret, though we still don't have the updated SWIP, right? But again, we don't have to vote on it, so.
Yeah, there's some information that
Yeah,
we did lead agency circulation last March.
Sorry.
Yep, so that happened. There is some information that we talked about tonight that presumably the applicant will be submitting for the next meeting regarding lighting.
that'll impact secret.
Yep.
But if it's
some
drafted,
screening
we still
information.
we don't have to vote on it, so.
Right, exactly. The other thing I want to mention too, sort of related to SECRA, is this is also an LWRP site.
Right.
So we're going to need to, before the zoning board can act, we need to make an LWRP consistency determination. I know, I have in my notes that the applicant did submit
Yep.
the coastal assessment form. Did you also submit a narrative?
Yeah, it was in our initial submission, but we can resubmit it to be considered as part of the secret.
That would be
or another-
helpful, just to
yeah.
kind of bring it up to the forefront
Yep.
again. Because we will need to, in addition to doing
Yeah.
SECRA,
The
make an
LWRP
LWRP
consistency.
resolution as
Yep.
well.
So two things. Positive recommendation over to, or some recommendation over to the ZBA.
Right,
for
a
you,
recommendation or
right?
referral, yep.
And then SECRA draft. So let's.
And LWRP.
And the LWRP consistency, so to draft,
We need to, a draft, yeah, you
Yeah.
should direct preparation of a draft resolution for that as well.
that's a lot of stuff. All right.
A lot of work.
So let's take them one by one. Board, on the referral to the zoning board, any way you all feel we should characterize it or otherwise send a referral over without comment?
Just a quick question on my part, and it's really hard to open up these plans on my iPad.
Yeah.
Just because it's a really big file, so I apologize if this information.
It crashes on my
current
computer
plans,
all the
I was
time.
trying to find it. The issue is the rear yard.
Yeah, all right, do you want
Requirement, 50 feet's required, and it's about half of that, and so I'm looking,
It's the obscure jog in the property, so the irregular shape of the
Yeah.
lot. Yep.
the buildings that are currently there, what I was trying to find was they also are not compliant with that
Correct.
50-foot requirement,
Correct.
right? So, all right, so
They're
I just
existing
wanted to verify
non-conforming.
that was what it looked like. that-
You're correct.
I'd suggest saying that the proposed placement of the addition is the result of discussions with the planning board seeking to maximize consistency with other current structures on the property, and leave it at that.
Yeah, I think that's great. And as former chair of the zoning board, your thoughts on the matter are well taken. Thank you. I'm sure that would be super helpful to them. Did you capture that, Jennifer?
Yeah.
Yeah. Okay, so with that, and including David's observation, which has been recorded by Jennifer, I'll accept a motion to make the referral to the zoning board.
Motion.
Motion by David.
Second.
Second by Karen, all in favor?
Aye.
And then let's talk about authorizing Jen's office to draft SECRA neg deck.
Motion.
Motion by Randall,
Second.
second by Karen, all in favor?
Aye.
And then thoughts or otherwise a motion to direct Jen's office to draft LWRP consistency statement.
Motion.
Motion by David,
Second.
second by Karen, all in favor? Aye.
And you were going to close the public hearing, right?
Put your next application hat on.
Before we leave this one,
Yeah.
and I apologize if I missed this earlier, but did we reference the county comments?
No, we
Received?
didn't. And actually, I had that in my notes, even bubbled, so. I was just ready to move on.
It did take, so for the record, the county the referral was made according to GML 239.
Yeah.
The county did respond, which was in advance. So the letter was sent before the last hearing, it's been more than 10 days before, so now that's all part of the record. So you did get limited county comments, about the application.
I mean, the comment was it was a matter of local concern.
Right.
Kind of do what you want.
With comments.
Or don't ask us.
They're not I don't know if they
Keep
were
it in the family.
mandatory
No,
comments.
there was some comments about crosswalk.
Right,
Yeah, that's right.
Oh, okay.
right, the 130, 193 and 95 also, but we'll get to that later.
So that's actually a good point. Your next month's review, I'm sure you're going to be including
Yeah,
some response.
all responses to everyone's
Right.
comments tonight, but that'll all be included. We need to address all the comments, obviously, Mr. Boolean's comments about the
Including
lighting, landscaping, it's all.
Okay.
Yeah, and you'll have the renderings, the updates, it'll all, I think, more fully come together. We were just trying to get a sense that where the things are evolving and how the things are being structured are getting there, and then it becomes procedure with the zoning board, with seeker, and having them be able to vote on the application. Ironically, I don't want to get too technical here, but setback variances are type 2 actions, so there is case law in different jurisdictions that say that we could, it's Jennifer shaking her head, there's case law in certain jurisdictions that say we could proceed without the benefit of a secret determination, but to the extent we don't have to deal with that next month, we won't get into the hairy scaries.
Yeah, we'll keep that lawyer talk to him then. All right. Okay.
John, can I make
Yeah,
one
please.
comment before
Go
we
ahead,
close
Kevin.
this out? I just wanted to comment generally, this is one of the applications that would have benefited if we had had a site section, if we had a requirement to provide a site section for large projects like this that are on steeply pitched sites. And I think we should not forget that we had suggested that.
I see the mayor's lurking, so maybe they'll change that reg.
I don't get to hear anymore.
Back there.
Oh, so
You'll see
truly
him peek-
lurking.
You'll peek his head.
Okay. Yeah, we did cover that quite a bit in our joint meeting with the,
Yeah, we're providing it. I
Council,
mean, I
so-
appreciate the comment. It is not a code requirement at this, but now for future applications, we're internalizing that for our own client and applicants.
I think it might be something more.
It's hard to put that, it's a lot of expense to go into something that you don't know is going to look like or get designed out of the gate. So it is a lot of expense for something you don't know will be a taste for the board.
It's worth it. I think it's one of the things that'll be beneficial to the design and the owner myself, but yeah, okay.
I agree with Kevin.
Noted.
Regardless, damn the cost. I mean, what does it cost to get a GIS, map?
You'll have it for next week.
Yeah.
Updated one session.
Okay, thank you. So we're going to move on to item number 2, which is public hearing and continued review of applications for special use permit approval, residential 829 Walcott Avenue, submitted by Lauren Walling. So first item of business on this is to move to open the public hearing. So I'll accept a motion to do so.
Motion.
Motion by Karen.
Second.
Second by James. All in favor?
Hey, good evening.
Hi, good evening.
Yeah, so this is 829 Walcott Avenue. We provided updated plans and removed the accessory apartment scope from the application because that doesn't need site plan approval.
Uh-oh, here he comes.
Oh, no.
Be on your best behavior.
All right.
It's just that
I was gonna, I
Nobody's
saw
here.
that, I was gonna call the cops.
Good thing security's
See something, say something.
Should we look around for more bags?
It was a test we failed.
We failed that test, yeah.
Speaking of Dutchess County Planning, they reviewed it and determined, and their response was that it was a matter of local concern, that they didn't have any additional comments. So basically, the application is to reestablish the bed and breakfast that used to operate a few years ago. This has 4 guest rooms. The guest rooms will be on the 2nd floor, and then the owner will occupy the 3rd floor bedrooms. So we talked about parking last month. There's a range from 3 to 9 spaces. We're proposing 4, and the owner provided a narrative about the parking related to the previous operation of the B&B, and tried to describe and demonstrate that the 4 parking spaces should be adequate, and the fact that there's some additional place that, if there's some big overflow, there's a loop driveway in front of the house. So, I mean, you got that narrative, so I don't know if you had additional thoughts about the number of spaces there. What else do I have? So, yeah, there's no changes to the exterior of the house, and we included some photographs to, just to show the existing condition. And then we'll add the bed and breakfast zoning, compliance notes to the plan, so that's on there for the record.
So, just as far as parking, the narrative does, give obviously historic kind of context to, what is traditionally, I guess, expected or traditionally seen and then future expected. Even goes so far as to say the inn almost never experienced a scenario in which all 4 guest rooms arrived by car simultaneously. That's interesting. I'm curious about how that works. If people, it talks about making their way from the train station and then I guess taking Uber or something. But regardless of that, the possibility still exists that 4 cars could show up simultaneously.
Right. And then I think, the applicant's discussion about that also included, there's that loop driveway in the front that has a lot of space.
Well, that's what I was going to get to.
They would try not to, utilize that, but it's there.
The driveway is in the front, and that's the key word, front yard parking,
Yeah.
right? Which the laws have changed since originally approved special permit for this. So I guess my question is, where I'm leading to is, should the need arise for 4 spots, I mean, the applicant wouldn't necessarily want to put themselves in violation by directing people to park in the front yard. And again, I understand the loop driveway context, and it's natural to park and part of that driveway on the loop, but it's technically not allowed, right?
Requires planning board or building inspector approval to do that,
One thing that I wanted to see if it made sense is, there is the room for additional spaces because that's what they had last time. Is there some sort of a land banking scenario where if it comes up that it appears to be a problem and the building inspector notices it, we can demonstrate that we can have those there.
That occurred to me too when I read the explanation that was provided.
Or we can go back to, and that's why I asked, and that's why I daylighted it, this context of front yard parking and the purview of the planning board to allow what has traditionally been something that's not necessarily what I would consider disruptive, and that is parking on the turnaround, right? So I think, at least my view, and we can talk about it as a board, is that there is the potential for 4 people all renting rooms on the same weekend and all happen to be showing up by car. And that would mean that those 4 parking spaces are taken. And then so it begs the question, where then would the owner park, et cetera. So my feeling is that you may want to be able to indicate the opportunity for additional parking.
Right.
And for me, 2 extra in addition to the 4, so 6 total, feels right. But that's just me, so we should talk about it as a board.
Yeah. Just to clarify, are you saying that we could
indicate,
show those on there, but
indicate
not
the ability to park?
Right. Even if they're parking on grass or something? Or?
In the back.
In a bind, you could do that, and that's kind of, I think, what...
Or on the turnaround, again.
I mean, there's room on, you have four parking spaces indicated. There's obviously room on each side, on each end of those 4 for one more car. And whether you do that, with grass pavers or you have temporary parking on the grass,
whether it's on the turnaround, which again, I'm not necessarily saying is a bad thing, right? Because again, it's the type of environment, it's the type of context that you would almost expect somebody to park. It's not out of the ordinary. So I personally don't think it would be an issue if you indicated those 2 additional spots in the turnaround or land banked on the grass or tucked in next to the other 4. whatever we think as a board and you as an applicant, through this conversation, think is appropriate.
Yeah.
I think
No,
that
I
would
mean,
make
that seems like a reasonable way to handle it. The motivation for reducing that larger gravel parking area is just to, get rid of the gravel and get more grass there and give a little more privacy to
Sure.
the future.
Yeah, and if in that case, what you're leaning towards, and I'll get to you in a second, David, sorry. If what you're leaning towards is the ability to land bank, or at least designate the ability to park in 2 spots on grass, that's fine.
Okay.
Sorry, go ahead.
just the rationale that was stated in the narrative, it makes a lot of sense to say, okay, you're not normally using these parking spots, it's a burden to maintain it, but given just what was just said, I just throw out there, because with this application in particular, it's probably something we should bear in mind. On Walcott, on Route 9D where this is, there's no street parking there.
No. Right.
Or anywhere particularly close to there. So this, let's call it social free rider issue, we're often concerned about. The owner of the property is going to have an incentive to make sure there's adequate parking for whoever it is showing
Right.
up.
Right.
So.
Yeah. Right, and again, I think that's the underlying point, is that, they're operating a business, they also have vehicles, and they'll want their customers to be able to park.
Yeah, just designating a little additional grass
Yeah.
as we could potentially put a vehicle here and keeping it as grass seems like a very viable.
I think the owner is trading in her car for a horse and buggy to keep it looking nice.
That'll be a spectacle around
Yes.
town. Okay, so we're agreeing that 6 is appropriate, and that you're going to look to, and it sounds like you're leaning toward land banking on grass.
I mean, if you have a preference, but, I think it's pretty easy to demonstrate that they can get on there, so.
I personally don't. I don't know whether the rest of the board does. So I think as long as you can demonstrate the 6, then I think that'll be fine.
Okay.
Yeah. So let's go to our consultants real quick, and then any other questions around the board, and then to the public. So we'll start with you, Natalie.
Yeah. I'll be brief, because I think my comments are mostly kind of cleanup. I think maybe when the change in plans of removing the ADU and stuff, just some things got switched, like the zoning cited as CMS rather than R110, so, and the zoning table just had some errors in terms of what was required. So I think just look at the zoning table, again, to clarify that. Screening for the parking, I understand, I'm hearing this conversation, I'm understanding that this parking has been here, it's being shrunk. So there is a fence there of some height, of some material. It's just not noted. And I mean, the aspect in the code is about screening parking from residential neighbors. So it sounds like you have it there. I think it's, again, just like a note on the plan, so that's confirmed. You said you're gonna add the required special permit compliance notes there. And then we talked about off-street parking. Again, I think the driveway makes sense for parking. It seems like that's historically been used. I think it's just worth documenting if that's the intent. The planning board has the ability to approve that as front yard parking. And so it should just be documented in the approval if the board is comfortable with that.
Thank you. Mr. Russo.
So I just have some basic cleanup comments that they can take care of quickly, but Jennifer, I had a question for you. So on the engineering plans, the ADU is still being shown. So supposedly that's been pulled from this, so does that actually need to be removed from the engineering plans?
I think that we can, ultimately in the resolution, make very clear that that ADU, even though it's shown on the plans, that's not part of this application, and that's not being approved by the planning board. That's subject to separate and distinct approval from the building department. So by showing it on the plans, it doesn't authorize it in any way.
Yeah, I think
We can put a
that
note
makes- yeah.
on the plan too, to that effect.
Yeah, I think that would make sense, because Mike, you can correct me, but I think it was sized, the piping and stuff was sized to include that, so we don't want to go, changing that.
No, and I
Yeah.
understand, but
But
the
we'll
ADU
just
was pulled
clarify it,
off, so,
right.
right, to clarify, this board is not approving that. I
Yeah.
understand why it's there, but
Okay. Any other thoughts, questions, notes for the applicant or for our consultants board before we go to the public? Okay, anyone here on this application who would like to share their thoughts? Please do. Wow, how many public hearings do we have where nobody says anything, including Teresa?
Yeah. Come on, Teresa.
Just a little something.
You must have something.
Oh, wow. New year, new Teresa. All right, I guess in that case, I'll accept a motion to close the public hearing.
Motion.
Motion by Karen.
Second.
Second by James, all in favor? Aye. Okay, and then we can also talk about, or otherwise, enter a motion to authorize Jen's office to draft resolution for adoption.
Motion.
Motion to do so by Randall,
Second.
second by Karen, all in favor?
Aye.
Aye. Excellent.
That's great.
All good?
Yep. Thank you.
Great, thank you. So we're going to move to our next agenda item, which is item number 3, public hearing and continued review of application for site plan approval, commercial 425 Main Street, submitted by Stanza Books. First order of business here on this one is to accept a motion, or enter a motion to open public hearing.
Motion.
Motion by Randall,
Second.
second by James. All in favor?
Aye.
Aye.
Good
Is
evening
it you
again.
too?
Yeah.
Great.
Yeah, so we updated the plans. There were a couple of comments. One was to update the tax map number because the property was subdivided by the city, and now it has its own tax map number. So that was updated. And we also included the light fixture specification. We had noted that it matches the one that was approved by the ARB for the overall building, but we specifically included it in, on this application as well. So, yeah, those were the only real changes that we made.
Okay, we'll go around consultants and then board. Start with you, Ms. Quinn.
Yeah, with the light, we just need the notes noted somewhere. You can put a note on there somewhere that it meets the standards for temperature and CRI, just as a requirement. That was it. Only comment.
Thank you. Mr. Russo.
We had no comments.
Wow. I have a feeling there will be no public comment either, but let's see. Board, any questions, other comments?
None for here.
Public, anyone here from the public who would like to share their thoughts on the matter?
It's a hat trick.
Wow. I'll wait another 30 seconds just in case.
Can
I
I
don't
object?
I don't want anybody to say that planning board chair, he didn't let us talk. All right, so I'll accept a motion then to close the public hearing.
Motion.
Motion by Karen,
Second.
second by David. All in favor?
Aye.
Aye. And then we can discuss or otherwise make a motion, enter a motion to authorize Jen's office to draft resolution for adoption next month. I have a motion?
Motion.
So, motion by Karen,
Second.
second by Randall. All in favor?
Aye.
Aye. I think you hold the record for the quickest.
Yeah, I know.
Yeah. Good job.
You want me to handle the next one? Yeah.
I know. You're right. We're supposed to be done by now.
Notice he sits down for this one.
Oh, yeah, so then we got a couple big ones coming up. All right.
Just
So-
sits right down.
Next up, when the lawyer stands up, you know it's going to take a long time. Item number 4,
My talking points are half a page.
continued review of application for site plan approval, mixed-use commercial and residential, 291 Main Street, submitted by Telephone Building Beacon LLC. Hello again.
Good evening. I'm a lawyer, so it's going to be a little while. My name is Taylor Palmer. I'm with the law firm of Cuddy and Fader on behalf of the applicant. I am joined, of course, by the one and only R.A. Siegel, our project architect. Since we were last before you in December, we did provide a minor supplemental submission that just adjusted the building design to incorporate what we call the Len alternative, i.e. the symmetrical brick piers. That was the only change, just to reflect what we had done last month, and the board seemed to have at least a quorum for that alternative. So with that, we did have a chance to review the secret documentation as well as the draft approval resolutions, and we didn't have any further comments.
Excellent. Okay. Anything we need to be made aware of by either yourself, Natalie, or John?
Yep.
Okay, so we have 2 items of business that we can discuss and act on, should we so choose. One is the secret neg deck. We have that available to us, which we have also reviewed. So if there is discussion, let's have it. Otherwise, we are in a position to adopt the secret neg deck.
Motion to adopt.
Motion by Randall.
Second.
Second by Karen. All in favor?
Aye.
Aye. So that's everyone? Do we have an aye, Kevin?
Oh, I'll abstain.
Okay.
Because
Understood.
I don't need to go in.
Good. Yes?
Okay, yeah, I mean, technically, under our rules of procedure that we just reviewed in the work session, if you're going to
Need to give
abstain,
a
you have to
reason.
cite a reason for your abstention.
Oh, I thought that John just waived my need to explain, but I'll.
How would I have to?
But I can
My
explain
magic
it. But
wand?
I have, still have ongoing concerns about its impact on, its impact on our historic preservation and of Main Street, et cetera, mainly having to do with the reduction of the visibility of the cornice. So, and I've gone at length about that.
Okay, and you want to abstain versus vote no on the secret?
I don't think it's material for me to vote.
I just want to make sure that we understand your vote, so that's an abstention. Okay.
So we have all other votes recorded. We have David, aye. Is that correct?
Secret neg deck?
Yes.
Yeah.
We have Kevin abstain. Sorry.
Yeah.
Motion by Randall, second.
Yep.
By Karen.
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 So make sure I got that.
Yeah.
Yeah, and then all others are in favor. Okay? And then that brings us to the draft resolution. Do we need any amendments to it at this point?
No, I just was going to mention one thing as we were preparing the resolution. And I don't know if, I don't think that this was necessarily discussed by the board, but I noted the fact that there's a rooftop deck on the addition. So I added as a condition that there shall be, no opaque or near opaque railings or, furniture or planters or anything on the rooftop deck that would obscure that western-facing cornice
Good
on
add.
the
Yeah.
telephone building. So
We accepted it, yep.
Okay,
Yeah.
good. Oh, and did we get any kind of disposition on 2 means of egress?
I'm sorry?
We were talking about earlier 2 means of egress from roof?
Oh, the two, no, I wasn't able to figure that.
So REA, take a look, the new code, section 1006.3.3.
Wow.
When you say stuff like that, you gotta say to the microphone for
Yeah.
effect. I'm just a roundabout way of saying, use your microphone.
And watch that shoulder. Watch that shoulder.
Thank you. So with that, there's something I think we should make sure that we document relative to how, this 2 means of egress ends up impacting the
That's a
use
building
of that.
fire code.
Yeah,
not
so the
planning.
issue is that the rooftop deck, I guess, John Russo, correct me if I'm wrong, but I understand there has to be, under the new code, potentially 2 means of egress.
Potentially, there may be some
Potentially.
exemptions, so even though there's a rooftop deck, if they don't comply with the state building code,
Right.
they may not be able to have that.
Yeah, which is fine. I mean, look, anything that's approved by any building structure or whatever that's approved
gotta
by the
be
planning
code. It's gotta
board.
comply with code, right.
Ultimately has to comply with the New York State Code when it's constructed, right? And that's a review that's going to happen by Brian's office when he gets the construction documents. If it turns out that they don't meet the New York State Code in terms of the egress. They either need to, they would just not be able to have the rooftop deck.
So, so if there's anything about the current application that indicates a usable deck,
Yeah.
like a door or furniture, those should be, in my view, not on the approved drawings.
Yeah.
If this
That would be done at the
doesn't
code
meet
review during the submission of the site.
No, I think John is talking the site plan. If the site plans are calling out for
Right.
rooftop deck,
Which it is.
and you approve the rooftop, or you approve the plan showing a rooftop deck, and then it goes to Brian's office, and Brian basically says, no, you don't comply.
It's in there.
So why don't we put as a condition that the rooftop deck shown on the site plan, is subject to compliance with
Yes,
the New York
so,
State
yeah,
Code
that's where I was-
requirements.
that's where I was going
And
with
if
it.
it's found not to comply, then it won't be constructed.
Yeah, I mean,
Won't
and
be
those
used
things
as a
happen
rooftop deck.
regularly, right? Where your building inspector is
Right.
looking at construction level drawings, and there's deviations from the concept level of a site plan.
Yeah.
And they have to either render those field changes as immaterial to what was decided by the planning board.
That's where I was going.
Or an amendment, or something rising to
Right.
the level of requiring an amendment by the planning board.
So it could potentially rise to a material impact to the site plan. Then they would have to come back,
Mm-hmm.
right? And that determine's all made by, this is all falling on you, Brian.
That's okay.
Yeah.
Okay.
Now it's falling on REA to.
Yeah, that's, you've got to check the code.
Is there any call out on the plan about what the railing is on the rooftop deck?
REA can speak to that. I know he's mentioned it before. It's the rooftop, the ramp.
I don't see any, I'm looking, but I don't see any.
Yeah, I think I saw something on there.
It's,
It's not good, yeah, I reached
no,
out to REA
I'd
with that
like
condition
more,
to ask if
I'd
it was
like more
okay.
certainty on what that's going to be, because of the, it's
Now I need
going
to
to
wait.
obscure the building, so it needs to be as fine and transparent as possible, like cable. So can we stipulate a cable rail?
Yes, cable
Okay.
rail,
Okay.
but now I need to wait.
Yeah, now we're gonna, so we can wait for Randall to come back from the bathroom. Anything else we want to discuss?
We have a fun one coming for you next month.
Oh, why did I create a third? Another
Whenever
three-year
Mercedes gets that
term?
meeting scheduled. Mr. Russo was unavailable for the first request. Everybody else was available.
I have
I
no
want
idea
it to
what
be
you're talking
different. Always watching.
It's usually the attorney.
So when Randall comes out, I want everybody to be staring at him.
No.
Who knew planning board could be so much fun? What?
This is my best board.
It is? Oh, it means a lot.
There is something shown on that elevation, right?
Yeah, there is, yeah.
On the north elevation, but no material call out.
All he told me, though, it wasn't opaque. That was the only answer I got earlier today, trying to anticipate Karen's comment. But that condition that Jennifer wrote was acceptable.
Looks like a 2x.
So you have notes you need for further amendments?
All good.
Okay. And if we adopt stating that we're doing so with amendments discussed this evening and as recorded by Jennifer, we'll be okay?
Yeah.
Okay.
Yeah, the resolutions we produce for your consideration are drafts.
Yeah.
Subject to amendment during discussion.
I was curious if, John?
Yes.
If Len's going to have a chance to look at these and weigh in on this?
You missed the meeting.
He missed the meeting, so this is his, because this was driven by, the design change was really driven
Well,
by
we can reasonably assume that unless anything's changed materially, it's exactly what he saw last month.
It's quite literally what was shown. We just submitted it as the formal proposal.
Is it, there's a label here that says metal guardrail with horizontal steel infill, color black? Is that? Okay, but that was what you were proposing, so we did have a proposal. We just didn't really get to see it.
Was it opaque?
It was, a detail would have been helpful.
It's a cable rail now.
Well, this rail is not visible from the street from me.
It is.
Can I make another comment?
So will the people partying up there.
Yeah.
Can I make
Yes.
another random comment? On Hudson Land Design's drawings, there's a setting in AutoCAD, I believe, that will eliminate the box around the text that makes it.
That's not an AutoCAD, that's happening after we submit the PDF somehow.
To,
I noticed that.
It happens on Macs. It
It's-
doesn't happen
It might
on,
be a setting when I print to PDF, and then it's making those boxes after it's.
you're on a Mac, right?
You would-
You're in an Apple product? For some reason, it only
Yeah.
shows up on Apple products. It doesn't show up on.
Because I don't have it on my PDF.
the PDFs?
And I've actually downloaded PDFs from the website, the agenda website, and there's boxes on those. I have a PC, so I don't know. I'll look into it though. It's
These
something
yellow
weird,
ones?
because the
Like
PDFs that I produce on my server don't have those boxes.
Yeah, I don't have
Yeah.
any boxes, and I'm on the
Also, what I
website.
download from your links
around
doesn't
the
have
text,
those.
and it gets very
It's only once it gets up on the website.
Okay.
Guilty. It's Mercedes.
Kevin, you have, you have different boxes on there?
Mercedes
Yeah.
doing it.
All the text.
Blame it on Mercedes.
Yeah, putting some pieces of it.
It doesn't work, but I've got
Oh, yeah, that's. And in AutoCAD, there's a setting you can do,
Yeah, no, that's not happening on those.
That's what I turned up, so I was like, how can you not fix this? I thought it was, that's how you really work.
We were waiting for you.
And so I apologize.
I may request a straw poll, but
Sorry?
since we're missing, as Mr. Byrne mentioned, there was another member who was supportive of the drafting resolution, Len. So may I ask the chairman to consider a potential straw poll? I mean, it may not be necessary, but,
A straw poll, so the
Would you-
applicant, so you're asking for a straw poll?
yeah.
Would you prefer that right now? Yeah. So we have the draft resolution. I'll query the board on, should we take this to vote, how you would vote. So we'll start at this end of the table. Mr. Jensen?
I intend to vote to deny the application.
You were here when we were talking about the rules?
We're not allowed to vote our conscience on this?
No gesticulating.
Wasn't talking to you guys.
Mr. Byrne, how would you vote?
I would vote no.
Okay. Mr. Williams?
The same.
You'd vote no? Okay. Mr. Vermeulen?
I vote no.
Okay.
I was voting yes.
Okay, I was going to vote yes. So,
I'm sorry,
Okay.
this-
Well, last meeting, we had a straw poll, so we'll adjourn the consideration for further discussion. And
I'm curious, because we, as a board,
Right.
voted to adopt SECRA, right?
Yep.
We also voted last month to authorize draft. So, I mean, I'm curious what changed.
Agreed.
So I prepared a statement of reasons that I was going to have put into the record. I can't say what changed with other people, but I can tell you what's motivating my decision. The historical preservation law seeks the preservation of properties that are of significant historical or architectural significance. Owners of designated historical properties cannot alter their buildings unless they obtain either a certificate of appropriateness from the planning board or relief from the zoning board. In deciding, quote, whether to issue a certificate of appropriateness, the planning board is directed to 3 statutory criteria. When, as here, the property is in the CMS district, the historic preservation law requires the planning board to consider additional criteria. Pertinently, it directs that any alteration or addition to an historic structure shall not damage or obscure the character defining features of the architecture or site to the maximum extent possible. In the context of this particular provision, it provides that standards using the term shall, in quotes, are required and that should, in quotes, is used when the standard is to be applied unless the planning board or city council finds a strong justification for an alternative solution in an unusual and specific circumstance. So the should standard is not what applies here. The information submitted to this board shows that a character-defining feature of the applicant telephone building property is the gold leaf cornice along the building's front and sides. This cornice is visible to people walking and driving on Main Street from both the east and west, and is singularly unique within our city. The proposed addition will almost entirely obscure the view of the cornice from the west. However, an addition would not obscure this view, or would obscure it much less, if it were confined to the rear portion of the building, or alternatively, if it were only 1 story in height, which would require an area variance from the zoning board. Thus, the proposed construction will obscure a character-defining feature of the property, and will do so beyond the extent that the applicant has shown to be possible, and accordingly, this board should deny the application. In approving the application, aside from disregarding the mandatory shall language in subpart B2, the board and its consultants are relying on an application of the principles set forth in the historical preservation law that applies them seriatim and in isolation rather than as a cohesive whole. So for example, subpart B1 requires additions to be placed towards the rear or at least recessed. Mr. Telly finds that although the proposed addition is only slightly recessed and thus, quote, may not be ideal, it, quote, does comply with the recess requirement. Mr. Telly then moves on to consider the language in subpart B2 requiring preservation of character-defining features, and concludes that while it is a judgment call, the proposed addition, quote, meets the requirement. Mr. Telly then considers the language in subpart B3 requiring that heights not conflict with the heights of adjacent historic structures, and concludes that the proposal, quote, meets the requirements because it is 3 feet lower in length. There is nothing in the language of sections 134.6 or 134.7 that indicates that the various considerations are threshold requirements that should be individually met, albeit barely, without regard to each other. The tacit disregard of the interplay between these considerations leads to a result that is plainly at odds with the letter and intent of the historic preservation law, which is the obstruction of a character-defining feature due to an addition's height and location towards the front of the property line without consideration of how these things relate to each other. So for these reasons, the board should be disapproving this application.
We had, and I'll speak to all of this, because we had 4 members of the board. I'll be interested in foiling communications between the certain board members that may have been circulated if Mr. Jensen's comments were circulated prior to this meeting, but I will certainly speak to, the prior discussion with the board. We had changes to the design, we had Mr. Tilley, we had your planner, we had our consultant, we had multiple representatives speak to what the code says and how it could change by the city council. We've met the full letter of all the laws, the zoning law, the CMS regulations, the HDLO regulations. All of your consultants have characterized it in such a fashion. We even adjusted the plan even further from all the design changes that went into this design to make the building comply even further with those regulations. The State Historic Preservation Office has weighed in on this. These are all interested parties, interested agencies, and consultants that have provided and said that this application satisfies those criteria. So while, Mr. Jensen, with all due respect, that may be your opinion, that it doesn't meet those criteria, the City Council would need to change them to make them mandatory. The shoulds, shalls, these are not necessary or not mandatory. We've had these discussions with council, we've had these discussions with consultants, so I'm not really sure I understand how, at this stage of the application, which was straw poll voted, it has not changed at all from the last meeting, to now see that there would be an additional vote for denial on the application, but we're going to request to adjourn, provide the information, put forth the materials that we'll submit to the court should this be denied. It really would seem a shame to have to litigate an issue that was already resolved and for an application that fully satisfies your code's criteria, but that would be the applicant's only opportunity to do so if the board does see to vote that way. And Mr. Williams, I think it would be very important for you to take a look, or I can make the full presentation if you'd like, about all of the material that your consultant presented. He came out, you went out and hired an outside consultant that reviewed the applicant's materials and said that it fully satisfies the criteria of the code, every standard. All of that was, we spent an hour and a half, 2 hours talking with the different consultants. We have our own historic district consultant. We even resent it to the SHPO saying, here's the changes, can you look at this again to make sure that there's no hanging chads here? And we had that all sort of discussed. Mr. Vermillion also voted to approve the application based on the prior change. So I'd be interested also to know, Mr. Vermillion, if you have any other comments about the application, because here we are at a position where it would either potentially lead to a denial if either Mr. Williams or Mr. Vermillion, or to the extent Mr. Byrne or Mr. Jensen don't change their positions. We will have to litigate this because that's our only option. And the applicant here has spent earnest money and time to ensure that the application satisfies your codes criteria. And all of the consultants, everyone has said we've done so. So I'm not sure how this application should need to proceed to the Supreme Court, but that would be the only option the applicant will be presented with.
Taylor, question, the professionals that you hired, right, those reports with respect to that, they're in the record. And then the city asked us to hold off on making any other action and hired your own consultant, Mr. Stephen Tilley. So the city has your own architectural and historical consultant who spent lengthy memoranda and details going through that. And I can certainly present some of those high points, but with all due respect, Mr. Williams, this application meets every letter of the law. Mr. Jensen has his own legal opinions as an attorney, and I respect that, but we talked about, and Jennifer and I spoke to this, and we talked about case law that represents this. An applicant cannot be required to pursue a variance alternative. That's just not permitted. So that's what Mr. Jensen has been requesting. The report from our consultant, respective to that, just touch on some of the high points, if you don't mind.
Sure. So let me pull up I'll try and pull up his notes, and I'll also try and pull up that report. So in our prior discussion, let's see, district planning, proposal. So it was back in November when we talked about Mr. Tilley's specific report. Concerns, increase the submission. Just Mr. Tilley's.
I have his,
Okay, so sorry, go ahead, Jen.
yeah, I mean, I have his report. I can read it into the record if that.
How long is it?
There's some introductory information. I can read sort of the meat of it, which is sort of 3/4 of a page or so.
Yeah.
Okay.
Is that okay, John?
So the introductory point just points out the fact that the cornice was in fact identified by the city council when it designated this building as a historic building under the HDLO. The cornice was identified as a character defining feature. And he goes through the HDLO standards, and he says, clearly in this resolution, meaning the City Council's resolution, the cornice is cited as an important feature and must be considered character defining as intended in the standards. That leaves the second question, does the addition obscure the building, to put it more simply than the convoluted standard language, as little as possible? The standard posits that an addition is going to be built and sets the rules to be followed when designing. Not building an addition would have no impact, but it is not an option for review. Building a one-story addition would obscure the character-defining elements from fewer vantage points than a two-story building. Zoning regulations for the Central Main Street District in Chapter 223-41.18, Figure 18-1, however, require a two-story minimum. So the analysis must be applied to the proposed two-story option. The lower height of the glass hyphen portion of the building accommodates some greater visibility of the cornice as one faces the building from the sidewalk and across the street. While a slight reduction in the two-story version might reveal more of the cornice from some viewpoints across the street and to the west, the effect would not be dramatic. So does the standard imply that increasing visibility of the cornice from 65% to 75% crosses the threshold from noncompliance to compliance. Absent quantitative support in the standard, we are left with a judgment call. Given the lesser height of the proposed addition and of the lower glazed portion of the addition next to the building, and the two-story downtown mandate that would also apply to any future replacement of the car wash building, we conclude that the proposed building meets the requirement in Section 134-7B2. With respect to Section 134-7B3 regarding height, the front section of the proposed building, as represented on Sheet 4, is 26 feet 10 inches from grade at the sidewalk and extends 37 feet 3 inches to the rear. In plan past the first section of the existing telephone building. No height is provided for the historic structure, but it appears to be at least 3 feet higher than the adjacent proposed addition. We conclude that the proposal meets the requirements in B3. An additional comment relates to 134-7A2, which states that compatibility does not imply historic reproduction. The proposed addition has the recommended cornice modulated so as to not compete with the landmark, but it also quotes identically the telephone building's brick rectangle surround and expressed by a punched rectangular recess that appears to be 3 to 4 inches wide and approximately 2 inches deep. This element seems extraneous and out of scale on the much smaller addition facade and an instance of historic reproduction, out of keeping with the guideline. Its removal, in our opinion, would be consistent with the otherwise generally sympathetic massing and materials and would avoid a false historicism of the proposed addition. And I believe the plans were revised to address that.
Okay, so like I said before, and I don't want to beat a dead horse, although I don't think it's dead, but the big issue, my biggest issue with this analytic approach, whether or not Mr. Tilley's factual observations are entitled to some level of deference, the question of how that standard applies is not, and by looking at those three metrics, obstruction of a historic feature, building height, and degree forward on the property as three individual requirements, rather than three things that work together, you're getting the result that we're blocking a historical feature because the building's too high and too far forward.
You have objectionable factual bases that were put into the record by experts, your planner, by the State Historic Preservation Office, by our consultant, who's a historic consultant, by the city's consultant. Your opinions are appropriate, but they have to be based in fact and not based on feelings. And this, we went through in detail with the board about how if the vote was not done based on factual information and just based on feelings alone, that itself would be arbitrary and capricious, and that would be overturned by the court. And then you'd be directed potentially without all the conditions you're considering to approve the application without a lot of the discussion we've had. So what we're trying to do here was design a building and update it to reflect your comments, and we did that. Last meeting, we adjusted the plan again to have symmetrical piers and columns. That was a comment made by Mr. Werner, who is not here this evening. So we adjusted the plan. We had 3 members of the board, not including yourself, Mr. Williams, who voted to approve, as well as Mr. Werner. So we had 4 total. I'm saying he's not here tonight, so in addition to Mr. Werner. So as far as the voting or the process, we had set this for approval resolution because we had spent a great deal of time explaining how each of these code criteria had been satisfied. Again, Mr. Jensen has his legal opinions, but the answer to that, as provided by your consultant and other staff, is that the City Council would need to change the law to reflect those opinions. And that's not presently what we are before you with. We are satisfying the letter of the law, and to quote even your own...
Taylor?
Yeah.
I'm satisfied with what I heard. That was the piece I was concerned about.
Understood.
Okay? Thanks. I don't want to...
Yeah, fair enough.
So look, I'm trying to be helpful here. It seems to me like probably an infinite number of directions things can go at any moment in time, but there's really 2 realistic ones here. We can make a motion to have a vote on this, maybe not, get 3 votes going one way or the other.
You need 4.
You can adjourn it and try to convince Jennifer and or ourselves at the next meeting that this is being misapplied. But unless I'm missing something, that's kind of where we're at right now.
Well, I think we're going to request the adjournment notwithstanding, but I am interested to know if there's some changes or other adjustments that Mr. Vermilion's interested in, because we were there with the alternate design, which all we did was submit that for the record and make sure that that was our defined project. So if there's something that we need to address for you, Mr. Vermillion, I think that's the only other question I have before we request that formal adjournment.
Yeah, I tend to agree with Mr. Jensen on a lot of things that he's saying there. For me, the big thing is the party on the roof. You've gone to painstaking detail to try to minimize the obstruction of the cornice, and then you put a deck up there. Right? It feels like it's, between the railing, between what you can do up there, between the view, the angle, and what Mr. Jensen says, it seems like it's just not meeting the requirements as it's read to us.
Well, the deck has always been there. It's set back 16 feet from the front of the building, so you're never going to see it from the street. It's pretty much immaterial to the visuals or blocking or screening of anything.
Right, there's been no change to the plan other than just the symmetrical piers. So that has been a component of this, and those changes were made in the building design. It was originally a 3-story building. It's been reduced down to 2 stories and stepped back in the rear. We adjusted the orientation. We added parking. This isn't just where we started and where we've ended. This project has been substantially revised, but that deck has been there as part of the application. We've adjusted that again, the glass to be able to see the building through the addition. Those changes have all been incorporated to reflect, again, comments from the board, but again, that piece of it won't be visible. Tonight, we were just getting a detailed clarification on the railing that was with that deck. That will also not be visible.
Why do we need a detailed clarification on the railing if we can't see it?
We were asked for it, yeah. I mean, we just wanted...
Why would you agree to it if you don't see it?
I think you will be able.
Of course
You will be able to see the railing from the west side, like.
My architect, he is saying, I'm not disputing it, but
Your
It's not in the
rendering
rendering.
says otherwise. You're going to be able, even though it's not in the rendering, you'll be able to see the railing.
Understood. Well, we are requesting an adjournment, and ultimately, I guess we'll see you in February on this application.
Okay. All right, thank you.
Just for the record,
Hang on, so one at a time. Sorry, Randall.
I just want to say, just for the record, my vote would, what I was concerned with was addressed by our professionals. All right, so I don't, as you know, I don't base things on opinion. I just needed to clearly understand what they said with respect to where we stand now.
Yeah, no,
Right.
clear,
Okay?
clear. Somebody else have something?
Yeah, I just wanted to make one point, which I think I made before. I don't want to go on about this either, but that recommendation that he made excluded the option of not having anything in the alleyway. And I don't think that that's inherently required, right? I don't think he had to exclude that option. Just because the applicant only
So all he did,
provided-
Kevin, all he did, and we need to move on, all he did was recognize that it wasn't an option for review because it wasn't a part of the application. That's all.
The standard that we're applying is whether to grant a certificate of appropriateness, which ultimately means yes or no.
Right.
I'd be remiss to not ask Mr. Vermillion, if the deck were not included, would you approve the project?
Yeah, that's
Okay.
my concern.
Thank you.
It may not be, based on code, so, all right, we'll talk more about it next month.
That's an irony of ironies.
Depending on ingress and egress, you're right.
Can't make it up, right?
Okay, so we're going to move to our next application, and that is item number 5, continued review of applications for subdivision approval and site plan approval, residential 6-unit multifamily dwelling, 193, 195 Main Street. Good evening again.
Good evening, and buckle up.
Did you want to shake it off?
This is a full presentation. Oh, no. Oh, we'll get there. We'll see how quickly I can talk it through. Good evening, Taylor Palmer with Cuddy and Fader on behalf of the applicant, joined by Aria Siegel and Mike Bodendorf, as well as Rich D'Andrea. As you mentioned, Mr. Chairman, we are here in connection with our continued review of our site plan and lot merger application, proposing to install a new 1 and partial 3-story addition to the existing mixed-use building at the property that makes up the two lots that make up the property. After our discussions with the board back in December, we did consult, and comments made by the building inspector, again regarding a building fire code question. The applicant took some significant steps to try and adjust the building program, and in particular the vehicular and pedestrian access to the addition. These changes to the overall site design are detailed mostly in our December 30th submission, and there is a letter that we did just provide to Mercedes late this afternoon. We'll be submitting that. We're not asking you to consider it tonight, but just for your records. We did include a copy of the signed vehicular and pedestrian access easement with the abutting property owner at 8 Cliff. So now that enables the fuller access, or without any vehicles to have to travel onto their property to get to the back of the building. With that, now we include an ADA parking space. And we solve one building fire code question. No, sorry, good point, Mr. Murphy. We put it back. Because now we can legally access that without going over that. Not that we couldn't before, but now we have a legal easement, permanent easement, not a license agreement, permanent easement over that. So we've submitted the signed copy of that, but we'll get the recorded copy and include that for the files. Before I do turn it over to REA to walk through the design changes that also reflect that, and Rich can talk about the parking and circulation and a parking diagram for getting into the site. Let me just give you a quick overview of some of the other changes. So of course I did note that we now have the one ADA accessible space at the rear of the property. To make room for that parking space, the dimensions of the addition were of course modified and the floor plans were adjusted. So the proposed residential apartments within the addition have been adjusted slightly as a result. A concrete walkway will be installed to connect the proposed parking space to the residential entrance of the addition, and 2 safety bollards are proposed near the entryway of that addition. The addition, to facilitate the vehicular access and turning movements to that accessible space, we of course obtained the private easement from the adjacent property owner at 8 Cliff for that purpose, and that we included in our letters today, and we'll get you the recorded copy. As we discussed at the December meeting, the entrance exit to the driveway connecting to Cliff Street and the front courtyard area for the addition are proposed to be developed with the permeable concrete pavers and grass grid pavers with grass-filled void. The proposed easement area will also include that paver design, so that little corner, which Aria can kind of highlight, or Rich can walk through when we go through it. A Belgian block curb is also proposed to be installed along the perimeter of the driveway that abuts that 8 Cliff Street residence. That was based on comments from your traffic consultant for the application to provide additional protection for that adjacent property. And then we'll note specifically, because there was some back and forth on this particular issue, the pedestrian access that was proposed out to the city's lot, we've removed that from our diagram. Lastly but not leastly, in response to comments from the board in consideration of the HDLO and CMS design standards, the false concrete block windows and the eastern facade of the addition have been replaced with recessed brick sessions, mixing the words together. There were also some adjustments made to the landscaping areas to account for that proposed parking space. So with that, Aria, if you want to walk through the site design, then I'll have Rich orient you all on the site access and the adjustments.
Get the right plan on there. Yeah, so the issue we had been having for a while is that in order to get vehicles back in there, there was a conflict with the, the property line of that neighbor at 8 Cliff Street. So the applicant spoke to them and got an easement, so we now can, make the turn for ingress and egress. So then we were able to provide the handicap parking space there. And, Rich will go over the turning diagrams, but that all works. We adjusted the building design to allow some of that turning to happen, so there's a big step back. On the, if you're looking at it, it's on the left side of the building, if you're looking at the south elevation. And that, we changed that in the site plan, in the floor plans, and in the design of the building.
And you say the walkway across the city parking lot's coming out?
Yes.
Yeah.
You want to remove that rendering too, then?
Oh, yeah. We're going to update the renderings because I also just wanted to make sure we're on the right track with the changes to the building design.
Mm-hmm. Okay.
What else did I have
Anything else?
here? No, I mean, that's basically, you know, what I tried to do with the building design was address the things we had spoken about. The, you know, we have those blind windows on the east. So what those are going to be is exactly the same masonry opening, but they're going to have brick infill, which, you know, as some historic buildings have in Beacon, so just to make it look fit in, you know, so it's not some other material introduced to that. And then, you know, the other thing we did is Len had recommended that we put that tower on the northwest corner. You know, that raised section, because that's where you're going to see it. So we did that, you know, sort of worked out the cornice details, got further on the base detail and how it integrates with the window sills. So, you know, I just wanted to see if that was working. The one other thing that we're going to propose is to have a light on the neighbors, you know, the 8 Cliff Street neighbors garage, so we can light up more of that driveway. We also have some, these are photographs that we just got, you know, these are at night showing the existing street light there. So there is some light from there. We're going to supplement that with what we can get on the neighbors, and then we'll also, you know, if we're good with this plan with the parking, we'll get the lighting on the building to, you know, cover that area.
And just going to steal that from Mike for a second from REA, just from Natalie's purposes, since the lighting we're talking about could be put on top, put on a building in adjacent property. I mean, naturally, we'd have to have an agreement with those parties, but to the extent that it meets the letter of the law, I guess is something we'll want to confirm with you and Brian, that we could use lighting off of another property. Meaning we're putting a light off of another building, which would be a different property, so there wouldn't be the spillage issue, I guess, is what, if I get to the point.
Yeah, that's not a problem. What kind of fencing is this? Is there fencing around this driveway? No? Just
No.
Hey, Artie, I got a
Yeah,
question.
it's just the existing driveway to the rear. We're improving it to be Belgian, like a permeable paver system, because it's going to be utilized almost exclusively for pedestrian access. It will only be, to the extent the existing property owners on each 8 Cliff Street has an easement, and then the garage that's behind that we would consider putting the lighting on that uses this driveway, which is why we thought those two things make sense. That property is the only those are the only vehicular, other than our one ADA parking space that will be back there.
You could just use bollards in the grass area on the side to solve everything and not have any light pollution.
Yeah, I think the issue is that I think the total width of that driveway is tiny bit over 2
Right.
feet.
The grass grid paver with woods for the, oh, so you could drive over that.
We thought about like a strip or something, but then that wouldn't be dark, presumably wouldn't be dark sky compliant if you used like up lighting on the pavement in the paver.
And I think, you know, they have those
They have the saucer ones that are those compliant? You know, the ones you could drive over, but the lights are just around the edges?
Yeah, but one snowplow, take them out.
Yeah,
And
it
that
might be
could be
considered
obvious.
up light. I don't know if they would necessarily consider those.
we can also look at lighting in that curb that we're providing. I don't know if they still have it,
It's a
but
tough
Jim,
one.
they used to have those like paver blocks, like
Yeah.
glass blocks that lit up and you could drive over them, but I don't know if that's dark sky compliant.
It's anything that you drive over in the northeast is going to be rough with the snow and the snow plows.
Yeah, I
And
mean,
then
those are like fully flat into the.
Yeah.
It's not the one that Karen was mentioning with the ring, because that's slightly raised.
Gotcha. You'll be addressing it somewhere.
We're going to address it, yeah, I think something that wouldn't rise to a potentially significant adverse environmental impact, but we know that we need the formal lighting. We're just trying to find which is the best mix of how to do it right.
Those wouldn't necessarily be dark sky compliant, but I think they would, it'd be helpful to be able to see them and then respond in the code, but the code doesn't necessarily say anything about uplighting. That's a dark sky compliant standard, but that's not necessarily adopted within our code. Our code talks about cutoff fixtures and stuff like that, and spillover onto adjacent properties, so.
Right, and it's pretty bright with, like, this is similar to what discussion we had last month with the 416 Main Street application. There's those two lights there. The city's parking lot also has a lot of light, so where we are is a pretty lit, it's lit. So we'll put it together for you in more details.
Is that your alleyway that you're showing right there, your driveway that's across the street there, where it kind of gets darker between those two buildings?
Yeah.
And this is gonna be your primary resident entrance, right, for the 6 units that are going there.
Yep.
And so I do appreciate what's been done with the paving materials to try to make it look like a shared use path rather
Right.
than just
A
a
driveway.
driveway, because this is gonna be their primary entrance. But I think lighting is gonna be essential to also signaling, not only to the pedestrians, it's safe to walk down here, but to vehicles,
Yep.
be careful, there's pedestrians walking here,
Okay.
right?
Yeah, we just wanted to give you a sense of where we are hoping to go with it,
Yeah.
and that'll be in for
That's a tough
February.
one.
The SketchUp images 4, or view 4, 5, 2, and 1. Those, I'm assuming, are the most up-to-date.
Yeah.
And I'm just curious, the surrounding context, is that accurate? No.
Semi.
I'm asking a question I know the answer to.
Yeah. I mean, apparently it finds that. I mean, it's where it's supposed to be, but
Well,
I don't know how accurate it is.
for example, in view 4, if we're looking north, there's a whole row of buildings along Main Street that are missing, as well as the context of the surrounding,
Oh, yeah. No.
the fence and the.
Yeah.
My point is that either through the more realistic renderings or through those views, we really need to understand the context that this is in.
Right. Now,
So-
our plan is to do it in the photorealistic rendering, so this was what we could do.
I understand, you're basically, these are working images, right?
Right.
So that's good to know. We'll be able to see more photorealistic representation of the actual proposed building, but also its contexts from these vantage points.
Yeah.
Is that what you're telling me?
Yeah.
Okay.
I have a quick question on view 3. The first floor windows, they're just shaded, right? They're just normal windows, just in the rendering, they're shaded dark. They're on the first floor of the tower.
Yeah.
Okay.
This is the, whatever happens with the rendering, but yeah, those are windows.
Okay, and then there's false windows in what I presume is the stairwell
Yeah.
facade, okay.
Yeah.
Thank
we
you
have-
for pointing
Can
this
we
out.
can we have real windows in the stairwell?
They're shown real in the plans, so you have to coordinate.
Yeah.
Doesn't code deter?
Another one for you.
I mean, what's going to happen is, I wanted to talk to you about that, because that would be almost a third kind of window, because they have to be,
They have to be rated.
yeah.
Well, either, yeah, I don't know.
I know
The way
you don't want to go
you,
to glass block.
glass block and chain link fence are on my list for annihilation. Whatever you do, maybe give it some deeper consideration, because just the way you have these random zigzag recessed, they're not windows, but those recessed elements, the arrangement of them is off-putting.
Yeah, I mean, part of that is because it works with the mid landings. So they're not going to line up with the regular windows, but.
Yeah, well, so the way you're showing them here, yeah, they align with the landings, but they're not doing anything. So they're not windows.
Yeah. Well,
So why are they there?
I mean, maybe you could just have a brick detail as opposed to window, false windows.
Something.
Yeah, I would submit that you don't necessarily need windows there, right? It is a stair, it just adds an extra layer of complexity, and
Yeah.
they would need to be fire rated, and it introduces yet another visual element, right?
Yeah.
And so if you don't have windows or recesses there, what else could you do? Or does it lend itself, and would it be okay with nothing in that zone?
Right, well, yeah, that's kind of what I wanted to ask. We could get, functional windows in there and we could get them to look like, pretty close to the actual windows, but
You could use the,
they would have some,
sorry.
difference to them.
Personally, I don't think you need to introduce a completely new element there. And if you're not, hell-bent on having, daylight in the stairwell, which you don't need, and I would say don't put them there.
Yeah, that would be fine as well.
And again, that's just my opinion. Others can weigh in.
You could use the diapered brickwork that's on the side of the telephone building that will no longer be in public view.
Okay, so from our planner, Ms. Quinn, any additional comments you want to daylight for us?
No, I mean, they're mostly retained from the last meeting. We talked about lighting, and especially lighting, I think, on the pedestrian access / driveway. The landscaping area, maybe check that calculation, looked like you were showing below the required. And then for this one, again, I guess maybe this gets handled at building permit, so that's fine if that's what the building inspector decides, but with a building like this going lot line to lot line, where footings are going and stuff like that, construction details, staging, all of that during construction becomes very important for a very tight site like this, so I don't always ask for that on a site plan level, but I think for this one, I am curious to see how that's gonna play out and whether there's something that we need to be thinking about in terms of additional, I don't know, in terms of like additional access or points like that in terms of construction details, staging.
Okay, Mr. Russo.
So I have a few carryovers with regards to stormwater still. One thing I've been asking for is that alleyway access serves as access for the garage on lot 10 also, correct? And where's the research that was supposed to be done on the easement access? Because it seems like that's completely disappeared off the plans at this point. There's no notes on the plans at all with regards to it. I've asked that to be.
We submitted in a letter, but we included the copies of the easements, but we can put that on the plans too.
Yeah, I've been asking for that over and over.
Don't make him ask again.
No promises.
Right?
Thank you, John.
Got your back.
I mean, it would all be incorporated on the, it'll be on the plat, so like this is a merger, so it'll be on the plat, but.
Yeah, well, there were notes at one time on the plat, they've completely disappeared off of that.
And now it will have a new note too, because we just got a new easement.
Right, so the next thing that I was gonna broach was.
So you're gonna add that to your letter.
They're going to need an easement into the city parking lot. That's going to have to go to the city council.
Is that so?
We removed that.
Wait,
That's
that came
being
out.
removed, right?
Yeah.
So we had this discussion at the last meeting. There was a question about whether that was still being proposed or
No,
not.
this is for the piping you're putting in the city
piping,
parking lot.
Okay,
Piping easement.
did not know that, okay.
Yes.
So pedestrian access through the city parking lot is no longer being
Correct.
proposed,
Right.
but there is it water or sewer?
It's
What
drainage.
drainage, okay,
Drainage, and it's
stormwater.
tying into a city structure in the city's parking lot there.
Thank you.
Thank you.
You're welcome.
All right, board, any other observations, questions?
I got a couple.
Yeah, please.
Since you got the easement, is this a standalone building now, or like a tricky extension?
So to clear, so the easement is only over, if you want to just highlight it on the plan, the easement that we got from 8 Cliff Street is just literally a corner
Right.
where the cars drive over, so there's no difference.
That wasn't the reason why you changed this into an extension.
So what had happened was, so Mr. Murphy had made a comment that because we're new residential, that's proposed as part of this application, that if we are proposing parking, it had to include, meaning if we had access, if we had full access to the site, which we didn't have prior to getting this easement, we would be required to either have an ADA parking space, or we'd have to get relief from the state as a form of a variance from the state building and fire code. So what we did was to get rid of that conversation based on the board's input that seemed to be pressing towards making it have the accessible space. We talked about that in a couple different contexts. we went and negotiated a private agreement with that neighbor so that vehicles could access it without trespassing onto their parcel. So now, full vehicle access means we need to provide an ADA space, and we are now providing said space. So before we didn't have, so I think what had
You're
happened.
building again.
We are building it now.
But you're a standalone building.
No, we're an addition, that doesn't change.
The addition is attached to CMS and HLO about having a primary entrance on the main street, right? So it's now an addition rather than a standalone building, so it is connected to the buildings on Main Street that have access to Main Street.
And all you have to do is just touch a piece of wood to another building and call it an extension. Because there's no throughway in this thing. Okay.
But that didn't relate to the ADA space.
He was asking about the standalone building versus addition.
Right, I just, for the purpose of the access and the easement, that, it only related to having, whether you needed an ADA space or
I
not.
just didn't know if we were,
I got
it just feels like a sleight of hand what you're doing here with this extension thing, but that's here nor there if it's legal. The only walkway for a family to get to this is now through that driveway? That cars can go through as well?
Yes,
Got it.
they can get through the city's lot, but again, it's not there's no easement, there's no right, anyone could still park there and, somebody that lives here could conceivably park their car on that lot and walk into the property.
Got it. I think the only thing that I have a concern about is someone getting hurt in there. If, I like going back to a mother of three boys, takes a turn in there and some knucklehead whips out of there, how do they get out of the way?
Well, so this is like a driveway like any other property. I mean, this is only there's two lots that can utilize this for parking, period. It's the lot with the garage, it's 8 Cliff Street, and then us. And there's only one, so no other tenants in our building can use this at all. It's just the one ADA space.
No UPS, no FedEx, nobody's gonna.
That isn't proposed.
I think it's a pretty simple
This is just an
question. Like,
ADA,
if a
yeah, it's
car's
just an
coming
ADA
down
access.
there And it's like a car and a pedestrian.
Yep.
There's no room left and right to go. They're gonna turn around and walk backwards until the car comes out.
I think that would be the case with any driveway for a use such as this, but I understand what your concern is, but for our purposes, it is we had tried a different way. We had tried to propose this as pedestrian only to the extent that the remaining, so right now, if this, under existing conditions today, anyone can go in and out, and it does. And for the most part, that's how it's operated. So we're trying to better that through the lighting operation, putting some curbing to protect the building, trying to create other mechanisms, the paving, right, changing how it's orchestrated to make it look more pedestrian and focus on the fact that pedestrians are going to utilize this. So we had our traffic consultant look at it. We responded to your city traffic consultant's comments about pedestrian and vehicular access, and we hear your concerns, but we've reduced that by really minimizing what vehicles can go in and out. Today, arguably, yeah, sure, I think the florist that had been there previously had driven back and through there, but they weren't permitted to do it, they just did it, right? That was just the easy way for them to get there. Has Beacon Bread probably done that? I'm sure they may have, but again, it's not within their lease for them to do so. So now we're restricting it explicitly to one ADA parking space. If there's a concern of like UBS drop-offs, we could, to the extent the board wanted that to be the case, we could restrict that to Main Street or...
Yeah, I'm just concerned of pedestrian walk, if that's the only walkway in there. I mean,
Yeah.
I know you have other driveways that are tight in here, but are they also used as the main entryway to walk into?
I mean, I think that makes
I don't
sense.
know where else that is.
Yeah, we can also add some signage at the beginning and end of the straightaway there.
See how he did that nicely. Yeah, please.
Yeah, I mean, just something to warn.
Yes, awesome. And my only other comment, I think, is that the trash thing still feels really light, right? The trash room, it's like 6 bins.
Yeah,
Does that seem light for a building?
We
6 bins?
reviewed that with the applicant, and he said he would, adjust his pickup if he had to, but he's comfortable with that it'll work based on.
So it's 4 units, right?
Yes.
Is that the trash for the front?
For the front building as well?
Yeah.
So that's for the restaurant, 4 apartments,
And-
recycling, and whoever else in that, 4 bins.
6 apartments.
6 apartments.
Oh, I'm sorry.
Yeah, because
6
there's
apartments.
2 in the original.
There's not
Yeah.
enough trash here, man. That's not enough for your restaurant, no less the whole building.
You need
Yeah,
recycling
I mean, I
bins, too.
think that the pickup frequency can make up for that, I mean, that's just how they arrange it with the sanitation company.
And the existing condition, as you may know, Mr. Boomen, is currently the dumpsters are in the city's parking lot, so those will be removed.
Plus, quite often restaurants have their own respective pickup for waste as well.
So what are you saying? The pickup would be more frequent?
Yeah, if they find that, you know, that it's filling up too much, they could
Yeah, they're
change
gonna
the
have to.
frequency. Yeah.
But the apartment buildings use the typical
Yeah, the Royal Carting.
Royal, so how do you get more frequent if you're on the city pickup schedule?
Yeah.
It's only the restaurant that would be able to adjust the pickup schedule.
Yeah, you know, that's a good point, Jim, you raised. Also, what is the access for example, Royal Carting? Those poor guys gotta
Yeah, well, they're gonna
park
roll
their
it.
truck, make their way all the way up to that
Yeah, go down driveway.
garbage thing and then roll them down the driveway? Or is the owner gonna bring them all the way down the driveway?
And then you have 6 cans.
Yeah, I
And
would
then
in front of
assume
your
that
neighbor.
the owner's going to bring them.
Right. Right, then you're bringing 12.
12
you've got-
cans
you've
of
got-
restaurant and
Well, now you've got trash and recycling for each unit.
I mean, our existing condition is not, I think, functional. I mean, the Beacon Bread today puts it into the dumpsters
Hang
that
on,
are.
we're talking about two different things. Your existing condition is convenient
Right.
because it's out in the parking lot.
Yep.
Or at least as convenient as it's more convenient than it will be. So the restaurant trash is one issue, right? What is the access for loading that into the garbage truck? And then the residential, this idea of 12 cans out on the street in front of their
We'll look at how
adjacent
we have
neighbor.
to address it. We'll put in, we'll either, whether it will be private or some combination thereof.
Yeah.
We'll have to address it. I mean, I know these options exist because, Beacon's not the only city that has that trash, collection concern. So we'll get it on the plans. We'll go from there. Also, just as a note.
Every city has trash collection.
Yeah. Well,
We're
I'm saying, Mr.
talking about
Jensen-
this particular
Well, what-
site
Right.
and how the volume of trash is going to be handled.
Just as a recommendation, because having been a client of Royal Carting many times, you really want to understand.
Your mic's
Your mic's off.
You really want to
I think your mic's
understand.
off.
Sorry, didn't realize, sorry. You really want to understand what the requirements of where those cans need to be for them to pick up. They do not like chasing garbage cans at restaurants. It becomes extremely expensive.
And just one other note, just on Beacon Bread, we did submit it today, just via email, because we just received it today. Mr. Jensen had brought up that there were comments. I know it's not the public hearing yet, but there were comments from Beacon Bread. Those have been resolved. They've worked out with the property owner and have said, retracted their comments.
Okay, good to know. I mean, I just raised that for the basic premise that any factual information I'm getting that relates to this board ought to be coughed up at these meetings.
Yep.
What was the concern that you brought up?
Oh, the lessor Beacon Road of the premises had sent me and I think Mercedes an email, and I think the owner as well, saying that he thought it conflicted with the proposed development conflicted with their lease rights. So I said, I got this email and I don't really know what else to do with it.
Right. And it's now moot because they've withdrawn that
Yes.
complaint or concern, whatever you want to call it. Observation.
You're right to
Okay.
use the word redacted or retracted.
Okay, so we talked about planning and engineering. Any other questions or comments? We have some work we can do, including scheduling public hearing and directing secret draft neg deck. So which one do we want to do first? Secret neg deck? Thoughts on the matter? Motion to authorize Jen's office to draft such?
Motion.
Motion by David.
Second.
Second by Randall. All in favor?
Aye.
No.
No? You're
I'm
voting
in a
no?
no mood, sorry. No.
Okay.
Was that canceled or you keep moving?
No, we have
need my vote?
majority, so.
Okay.
Then we can also schedule public hearing for next month if we see fit. So.
Motion.
If there's no other discussion,
sorry.
Yep, motion by Randall,
Second.
second by Karen, all in favor?
Aye.
Aye. Okay.
Thank you.
Yeah, thank you. Okay, so our final agenda item for the evening, which is new to us, and this is the review of an application for amended site plan approval, commercial, 3 Beekman Street, submitted by Dia Center for the Arts. New parking lot.
We get fancy.
Wow, and then there was one.
Yeah. It's the first.
You don't have the whole band with you? These guys, oh.
I didn't let him play on this one.
Solo, he's doing it.
Wow.
Going
Taking
solo.
your chances, buddy.
Okay.
Just
Good
curious,
evening.
Why did you include all the, like, property deed stuff? With the submission?
I'm sorry,
The property deed stuff was all included with the submission, and I was just wondering, like, why?
We're supposed to include the deed
Are
in
you-
the application.
Okay, well, I guess that's why then. Most applicants don't include that.
Okay, for the record, Mike Bodendorf, Hudson Land Design, engineer for the applicant. Dia parking lot expansion, 3 Beekman Street. We're all familiar with Dia, I assume. So the plan you're looking at here, main building, and just north is to the left. Main entrance off Beekman Street, public parking lot, employee parking along the east side of the building. Existing, this is all existing, by the way. Exit, access road, overflow, employee parking here, and I'll get to our proposed 49-space parking lot, 5 additional spaces in the existing employee overflow parking lot, and a 60 by 70 storage building. Just a point of clarification, my letter stated that this is in the HDLO. According to the latest zoning map, it's not. However, it is in the LWRP. So we do need to provide a consistency statement.
Is the building identified as eligible or listed on the National Register? Not by, not designated by the city as historic, but,
I think it is listed.
yeah. Okay, yeah, I thought so.
Yeah, I was just pointing, it's not in that, it's not
not in the
hatched in the
HDLO,
zone, but
yeah,
it might
okay.
follow, it might meet criteria for that.
Yeah.
So from the proposed parking lot, we're providing a sidewalk extending to Beekman Street. And as I mentioned in the other application earlier, they do have an agreement pending, or working on an agreement with the funeral home to utilize this parking lot when they're not using it. They expect to use it on weekends when they're open to the public, where events might be happening, or maybe a weekly event, but generally that parking lot won't be used during the week. So 49 spaces in the new parking lot, 5 additional spaces in the existing parking lot, new building on the south end. The disturbance will result in over an acre, so we're preparing a SWIP for this. We do have the preliminary stormwater design shown on the plan. We need to provide a SWIP report that provides all the supporting documentation and calculations to go with that. We have shown some conceptual landscaping and conceptual lighting on the plan. Those needed to be developed further. We're showing some evergreen trees to screen the residential properties to the east. We're looking at providing additional mixture of deciduous and evergreens along the east side of the parking, mixed with some evergreen shrubs to soften the parking. And, similar to what we did at Mirabeau, we have a retaining wall here that varies in height from anywhere from 2 feet to as much as 5 feet at its highest point. So that, coupled with the landscaping on the east side of that, should soften the parking lot. It's not going to screen it completely because the view to that parking from Beekman Street is so much higher. But the mixture of trees will help, you know, soften that over time. For seeker, I believe this is an unlisted action. The only outside permit we're seeking is a DEC SWIP. The storage building isn't proposed to have water or sewer. We're just looking to provide electricity for lighting and heating.
I'm just curious on the, hopefully I didn't miss it, because I feel like I've looked at everything, but are there further details on the new storage building proposed? In
Is there?
your
I'm sorry?
application? Just further information, further details.
So we do have an elevation. We've gotten some preliminary drawings on that. It's a steel building. It's going to be designed to look very much like the existing storage building that's right here. So steel building, aluminum, it's not corrugated aluminum, but that, not standing seam, but you know, that aluminum shell, green in color. If you would like, I could show you the preliminary elevation that we
Let's look at
received.
some more details on it. Yeah, I mean, this is both the parking lot, the new parking lot and that shed are set well below the elevation of Beekman as you come down.
Yeah.
So, you know, the sight lines are a little odd. I'm sure you're going to see the shed.
The roof in particular
Yeah.
is going to be important.
So I'd be curious to see what the proposal is there,
Maybe you could do a green roof.
meaning like living plants.
All right, so do you want me to show the preliminary elevation?
You have it here?
Yeah.
Yeah, sure. Let's get a look at it.
Quick question, the additional parking, is it just for cars, or is it for buses or anything else, or just cars? The proposed parking?
Cars, yeah.
Okay.
Well, you got a green building, not a green roof.
So this is the side that would be facing the parking lot.
Can I just say something? That's ugly. I mean, are they,
It's okay. It's a museum.
well, I mean, you've got this almost pastoral setting. I know we're adding additional parking lots to it, but I don't know. Is that, are they dead set on this? Obviously, I understand it's, you know,
Economic.
yeah, it's a kit, if you will.
Yeah, more or less.
Is this meant to?
It's like a Morton building.
Is this meant to house equipment to maintain the new landscaping? They're doing it in a very extensive, like earth art work, sort of.
On the backside of the building?
Park and landscaped area on the other side of the dia. I'm just wondering if that was their intent. They had a need for groundskeeping equipment that they didn't have.
Yeah, I think there is more equipment that they need with that. I'm not sure. We'll provide more information on what actually gets stored in there. I was hoping that one of the owner's reps would be here tonight, but they couldn't make it, so they definitely will be here next month to answer any additional questions you might have with that, as far as operations and what goes on in there.
Right, and I know this is a and I'm sorry, I don't want to go on and on, but this is it's a back of house space, right? But the other landscaping at the dia is really world class. I mean, some of the greatest artists and landscape architects in the world have had a opportunity to sculpt this special part of Beacon, and to miss the opportunity to use either disguise things that you don't want to see or make them interesting is, you know, it's an opportunity. I don't know if they're going to take advantage of it.
No, we are. We're getting their landscape architect involved in this. So I'm going to do my first run at it, and then they'll take it from there, basically.
Yeah, and that's all of that for all the reasons Kevin mentioned. I mean, just the context here, it is quite beautiful. This seems wildly out of context to that. And, you know, like almost like a blemish, a pimple in an otherwise, you know, really well-maintained and really nicely curated grounds.
Yeah, as I mentioned, it's going to look just like the other building that's already there.
Looks like they
I
got
mean, there's
one
already one of
already.
these buildings
Yeah, they did.
on the
They
premises.
got the approval for
They
that,
got
and I
one of
think
their-
2013, and then
Yeah.
2016 was employee parking lot.
Public can't go back there, I mean, the public can go back there, but they don't.
Yeah, well, again, it all comes down to how visible this thing is. And then level of consistency, right? If you have one already there and is it the same make?
Steel,
same
yeah, it's
color?
metal, aluminum siding, aluminum shell, whatever you want to, it's not standing seam, but I don't know what the proper terminology for that is.
Mike, have they looked at expanding or putting the proposed building next to the existing building instead of having
Yeah.
what appears to be multiple sheds all over the place?
Shedtopia.
I don't know if they could put it to the left of that building, possibly, the existing one?
Well, so we've got a drainage easement here. Taking on drainage, what I would
Right,
expect
that is there.
is from Walcott. There's a drainage ditch that sort of traverses through here. And then there's a relatively large sump here before it enters a culvert and goes under the road. So there's not a lot of room to fit another, at least a building of that size. We have quite a bit of grade difference between the road and here, so it'd require a lot of earthwork.
I'm just
There's a
wondering-
nice flat area to work with here. It just does require some grading, but it lends itself nice for a building.
I'm just wondering, could they landscape around it though? Because, I mean, you're going right from the building down a steep slope. Is there a way to modify the grading to provide some landscaping or modify the fascia of the building?
Yeah, we can look at that.
Okay. So any other comments you want to highlight, Ms. Quinn?
No, I think they've been touched on. I mean, I think the biggest concern here is that it is in a portion of the site that is closest to the roadway and closest to the neighbors. So looking at the grades on the site, it looks like that was chosen for a reason, but it is kind of the one the most visible. So the development of the landscaping plan and the lighting plan for how that will continue to be screened, because it looks like I think your plans show the existing trees, and you can see there's a number of them there that are going to need to be removed for that parking facility. So just, I think once we see the full landscaping of how that's going to be screened or bermed potentially to kind of keep that, it's unfortunate that a parking lot has to be in the front, but limited space. So I think just screening is going to be key.
Thank you. Mr. Russo?
So I would like to have some geotechnical investigation done in the area of the parking lot, concerns with rock in that area. So I know they'll also have to do some investigation in the area of the stormwater facilities once that gets proved out. But I want to know how much we're going to be dealing with as far as rock. And is there going to be a lot of hammering? Are grades going to get adjusted?
Okay.
I think, Mike, you said you've already done some preliminary?
Yeah, we did a series of test pits along this edge of the parking lot because that's where we'll be in a cut situation. Generally, it goes from a cut to a fill as you move from east to west across the parking lot. So we were concerned about rock too, just, from a monetary standpoint. So there's a little bit of rock cut that might occur here. I'll certainly provide that test pit information. But generally, based on the grades we have shown on here and the subgrade below the parking lot, we're above rock.
Okay.
For the most part.
You don't want to hit the shale. It's just hard. I don't know why. I just became a rock expert.
Geologist.
It's late.
I like rock expert.
It's late. Getting punchy.
We notice.
What else you got?
We've already touched on the stormwater, photometrics, landscaping. Mr. Bodendorf already noted that there's no water and sewer going to the building. It was one of my questions. Are the projects going to be phased? Is it going to be phasing as to what's being constructed when?
If it is phased, the first thing that will be built is the parking lot, and the building will come after that, but it could all occur at one time.
Okay. On the existing conditions plan, the easements should be put on. I know the description you submitted, Exhibit B, has a number of easements across the parcels. We'd like to know if any of those are impacted. Identify the trees to be removed in their respective sizes. With regards to the access from Beekman to this parking lot, that has to be widened to allow for two-way traffic. And then there was just some other minor comments overall.
Okay. Anything else, board? Questions, comments, notes?
Wondering
Yeah.
if this is an opportunity to request the early provision of a section, especially because of its steepness, right? I think we'll be able to understand the sight lines and what the visibility is. It may be, as we say, as people were saying, like, oh, you won't even be able to see it, you're just going to be looking over it. It may not be the case, and I think a section will let us know early on whether or not the landscaping is appropriate and effective.
Okay.
I agree.
Are we just looking from Beekman Street, or?
I think we can get away with one section from Beekman, to, perpendicular to the thing, and assume that it's similar.
Yeah, thank you.
Okay. Just as far as actions, lead agency?
Yeah,
We can authorize circulation of notice of intent.
Yeah.
Since there is another involved agency, DEC, we should do a coordinated review.
Okay.
And the other thing, before we do that, I just wanted to ask, this is LWRP. I didn't see a justification statement.
I need to provide that.
Yeah, okay.
So I need to
At some
provide a
point,
SWIP,
yeah.
I need to provide landscaping plan, lighting plan, and the justification statement.
So
And a section.
you're not actually going to DEC for SWIP approval? You're
Correct.
just filing the notice of intent?
Yeah.
So are they still?
We should still include them.
Right, but are they still
They're
involved?
probably not going to comment, but just on the safe side, we should include them.
In the notice?
Yeah.
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 Have we done that for every other project that's required a SWIP, or?
I think so. I mean,
Because technically the approval's from the city.
Right.
For the SWIP.
yeah,
It's just them filing notification that this work is.
yeah. Whenever there's a question, I tend to err on the side of just giving them the notice.
No, I just want to make
because it
sure we're
isn't-
being consistent with all the projects.
With
'cause
others,
I mean,
yeah.
if that's the case moving forwards, every project that would have a SWIP.
Would go to DEC. Yeah,
Right. Keep us in line.
yeah.
Okay, so I'll accept a motion to authorize Jen's office to draft notice of intent as planning board to act as lead agency in this application.
Motion.
Motion by Karen.
Second?
Second by James. All in favor? Aye. Aye. Anything else?
Can we schedule a public hearing at this point, or is it too premature?
Premature.
You heard it from the boss, man. And, sorry, yeah, we'll wait.
Okay.
Mercedes, you had something?
Not regarding this, sorry, I thought you were finished,
Okay.
but I do.
Oh, after we're finished, you have something. Okay. Anything else?
Just to touch on this PDF issue, this is the PDF that I submitted, and you'll see that there's not boxes on it. I'm going to look into this.
Oh,
There might be some setting.
You know what I get?
Yeah, you get the.
I get yellow sticky notes.
You get sticky notes.
What do you get? Sticky notes?
Are you doing it through the agenda, John?
Yeah.
I was too, and I had none of that.
I get a box, I get a white box.
You get the boxes. I get the sticky notes. It's
I'm
bizarre.
giving everybody everything. I just,
Yeah.
just a giver.
You're so generous, Mike.
So I'm going to look into this on our side. There's a new setting I'll try, we'll see what
Yeah.
happens. It's just odd. It doesn't happen to REA's plans, correct?
No, it does. It does.
Oh, we can't read those.
Oh, it does, to his as well.
We can't read anything anyway.
Oh, my.
Yeah. Another issue is the file size issue. I don't know if there's, how realistic it would be to do something going forward, but if the PDFs that were posted on the agenda were kept below a certain file size.
That's a good
Just broke it
idea.
up into different files.
Yeah, you
can't
can
open
compress
all
them,
the time.
the PDFs.
Well, that's the setting I'm using. I'm using the lowest file size, and I don't know if that has anything to do with it.
Well, but
I used to
I'm
use,
saying the city can break, if it's like a 15-page file, break it up into 3 5-page files, because those are much easier to load.
Yeah.
Or, submit them in smaller batches.
Okay, that's
but at a
fine,
different
yeah.
resolution. What's interesting is that the boxes that appear on mine, and what's funny too, is that it's only city PDFs. This doesn't happen on any other PDF that I open on any other, either my Mac or this. But what it's indicating is an AutoCAD. It says AutoCAD. for example.
SHX?
Yep, SHS text, metal platform. It's basically, somehow it's taking the info
It's taking
from
a shape
CAD.
file and doing something with it.
Yeah.
Something you have installed on your laptop, and it sits inside the browser.
No, that's what I'm saying. Like if I PDF something from AutoCAD at work,
Some setting
doesn't do
at
it.
the city's computer when documents are being saved that's keeping that
Something.
rasterized data where it shouldn't be.
The data's there, it's just being introduced in the browser.
yeah, anyway.
Yeah, I don't know if it's a version of Adobe versus my version of Adobe, or, AutoCAD has it built in.
There's ways to flatten and condense all these documents, and it might be like just a regular thing that you do, because I have the same problem with my iPad. Every time any of the larger, especially with the renderings, it kicks out and I can't review it while I'm in the meeting.
Do you flatten them in Bluebeam? Can you do that? Yeah.
Yeah.
Wow.
Is this only Apple or?
No, I get them on this,
It's just, it shows up differently on Apple.
but not
Thing
on
is,
all of the
it's not-
PDFs.
it's not all of
REAs, no, REAs are,
Shocking there.
Anyway, well, yeah, whatever you find out, if it's curious.
oh, yes, the engineering ones.
Yeah. You guys,
Hopefully we'll
you have
figure it
tech
out.
guys, right? Do you have,
No.
Sorry.
You have technical support for, like, AutoCAD things?
Who's ours? Outside IES?
Oh, okay, I'm just saying, like, they might be familiar with this particular thing. I'm sure they get calls about these things, I don't know.
I don't have a lot of faith in them. We're actually, if you guys know people, any local people to Beacon, let me know, because we seriously are looking for a new IT company.
All right, thank you.
Anyway.
Yes.
John, Mercedes reminded me about the announcement for 2 Cross Street, that their application is withdrawn. So I think we should just make an announcement.
Oh,
for
in the
benefit of
record?
All of
For
the
the
members of the
record.
public that are interested.
Yeah. So, yes, right, as last month, we had them before us for some modifications to site plan, basically based on materials, right? That application has been, for the record, withdrawn. And it's been withdrawn fully. Yeah, okay. So, noted. In the record. Great.
Thank you.
Thank you very much.
All right, have a good night, everybody.
I will
Take care.
accept a motion to adjourn. We have no certificate.
Motion to adjourn.
Motion by Randall.
Second.
Second by everybody. Let's give it to Karen. All in favor?
Aye.
I know. Somebody.